open this hearing of the Senate Economics Legislation Committee into the Competition and Consumer Amendment Australian Energy Regulator Separation Bill 2025. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via teleconference and in person. So we have Ms. Breakey, the Commissioner, who's online, along with Senator Smith, and everyone else is here in person. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard script is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matter of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground on which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. So I now welcome representatives from the Australian Competition and Consumer Commission. I understand that information on parliamentary privilege and the protection of witnesses to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? Maybe we'll start with the people in person, going right to left.
Yes, thank you. Lisa Ann as ACCC General Manager of the Executive Office.
Good morning, Senators. Sarah Proudfoot, Chief Executive Officer of the ACCC.
And Nicole Ross, Executive General Manager of the Infrastructure Division.
And Commissioner?
Thank you. It's Commissioner Anna Breakey, Commissioner of the ACCC. Thank you.
I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you very much for the opportunity to appear before the committee today in relation to the Competition and Consumer Amendment Australian Energy Regulator Separation Bill 2025. As noted in our submission, the Australian Competition and Consumer Commission strongly supports the timely passage of this bill through Parliament in order to facilitate the efficient and effective transition to a separate AER on the proposed separation date of the 1st of July 2026. The AER of today, with more than 400 staff and a 5-member board, is unrecognisable from the AER established in 2005, with 15 staff supporting a 3-member board. Similarly, the AER's regulatory remit has expanded significantly over the past 20 years, as has the complexity of Australia's energy market. While current arrangements where the AER and ACCC are a single entity under finance law and the ACCC chair is the accountable authority work, they come with increasing levels of governance risk. We consider establishment of the AER as a non-corporate Commonwealth entity will benefit the energy market and consumers through improved governance and accountability for the AER as it delivers on its vital regulatory remit. This view has been supported by a number of independent expert reviews over time. I note the AER is also appearing later this morning and shares our support for the passage of this bill, and we're very happy now to take questions.
Thank you. I think Senator Smith, you can go first.
Thank you very much, and thank you for your participation this morning. In your submission, you identify the Vertican review, the Finkel review, and the review of the Energy Security Board operator done by Mr. Edwards. Did any of those reviews provide any caveats or qualifications to their support for the separation of the AER from the AEC function?
Senator Smith, I'll begin there but then refer to Ms Ross. The Vertigan review, for example, noted that the AR should have full management and financial autonomy, and felt that was most effectively achieved by re-establishing as a standalone body, but I think was open to other measures. I think Dr. Finkel's review looked at the highly technical and sector-specific regulatory responsibilities of the AER, and noted also the particular focus on that of key stakeholders being concerned around it, and really framed it as a decision on structural separation being resolved. I'm not sure, Ms. Ross, if you have... I don't have anything. We could come back to you on notice, Senator, with further detail if that's helpful.
Yes, please. And if you could also just provide on notice why it was that the alternative scenarios that Dr. Vertigan might have proposed weren't in the end adopted, just for, I think, full clarity about why we've got to this particular solution. Thanks very much for that. Has any...
Sorry, so that may be a question also for the Energy Department, given it's a policy question.
That's right, and I'm sure that they're listening, so they'll be prepared. My next question goes to: has any agreement been made on how the appropriations within the existing government funding envelope will be shared between the ACCC and the AER?
Senator, could you please repeat that question? I missed the start.
Yes. Has any agreement been made on how the appropriations within the existing government funding envelope will be shared between the ACCC and the AER?
So currently the appropriations are divided into two programs, one being the program for the ACCC and one being the program for the AER, and those are what we report against in our annual report. Upon separation, the AER will take its full program budget, and the ACCC budget will decrease due to a reduced corporate contribution. So currently the AER pays for its employees, but also a particular proportion for IT and other things. And the ACCC, will make savings to realign our budget.
Okay. What are you able to quantify those savings or those shifts between resources?
We're still working through the detail of those, Senator. For example, we're currently working towards the AER remaining on ACCC property, so maintaining a presence in our buildings and also our IT network, but it will separate and have its own HR functions, for example. So we're just working through the detail of how that will work from a corporate perspective.
And what's the time frame on that work? When is it expected to be completed?
Very shortly, Senator. We're working through, obviously, as we've been preparing for separation at different points and at different positions where the legislation's been implemented and not. We've been looking to work on a no regrets basis, so not to go too far and invest too heavily, but also to be ready for separation when it occurs. And we would be hopeful that in the coming months, particularly if we have the passage of the bill, we can land that. There's been the subject of some discussion already.
Are you able to give the committee a sense of what quantums are involved without it being the final outcome?
I would prefer to take that on notice, Senator. I'll speak to our CFO and get something helpful for you.
Great, thanks very much. What has been the total cost of the preparatory work for separation and the transition activities outlined on page 2 of your submission?
Senator, there would be costs there associated with the individuals who've been employed to support the AER's finance, human resources, strategic comms and governance functions. Obviously then for the AER entering into the enterprise resource planning systems work, I'll leave it to them to answer that one. So I can't give you a specific quantity. As I mentioned, what we've been working to do is be in a position to effect separation in an efficient way, but not to spend too much money or go into a sort of a regrets piece in the event the legislation didn't pass.
So not to assume a legislative outcome before that outcome's been has been sort of approved by the Parliament, is what you're saying.
But to be ready should Parliament approve.
I understand. Again, perhaps you could take that on notice and provide some information to the committee where that's possible. What do you expect the total cost to the ACCC of providing property and ICT services to the AER will be?
Senator,
And how the
it wouldn't be any greater than current costs because we are already providing those services. We're co-located and the AER IT network is the current network, so it will just be working through what that looks like under a shared services arrangement, which, as I mentioned, we're still developing.
Okay, I think that is everything from me. Thank you very much, Chair. Thank you to the ACCC. Yep.
Thank you. Senator O'Neill.
Thank you very much, Chair. Thank you for your opening statement and for your evidence this morning, Ms Proudfoot, and welcome to all of you serving the public in the way that you are. Clearly, energy is a very important thing for all Australians, and we've heard from you this morning that you strongly support this legislation. Why is it that you support it, and why is it that you added that additional proviso of strong support?
Senator, this legislation, we believe at the moment we are working effectively with the AER. However, the AER board is a 5-member board with a very broad regulatory remit and responsibility. And so we recognise the challenges from a governance perspective for them in directing their resources as most effectively they can when they are not actually the accountable authority for those resources. And we believe that the additional certainty and control that would come for the board in having that responsibility and having its own accountable authority would provide, greater clarity. We think it would help the market because the board could, put out, while it already puts out very, very clear, guidance around priorities and work that they're doing. We think that could be strengthened by having that control over resources, and as such that there's benefits for the market and consumers also, which is our ultimate focus.
Okay, thank you very much for explaining that. You mentioned in your opening statement that the establishment of this entity of the AER 2005, you've taken some questions from Senator Smith about the Vertical report in 2015. It's now 10 years later. This is a dynamic industry where there is a great deal of change. Clearly, things have changed quite a bit. The governance matter that you speak to in terms of good governance, is it fair to say, Ms Proudfoot, that there has been a development of understanding of good governance in the period since the establishment of the AER, certainly, and also since the Vertical report?
I would say yes. Senator?
So a board of 5, which is what you've just described, is not what we would call excellent practice at this point of time, and there is a gap between the AER and the market in terms of clarity, transparency, strengthening of statements that would be enhanced if you're actually able to give this board its independence and make its own decisions. Is that correct, and why is this change necessary in your view?
I wouldn't quite characterise it that way, Senator. I think the board of 5 members provides, clarity and guidance to the market and effectively performs its regulatory functions. However, I think if I were a board member, for example, wanting to allocate resources and knowing that I had a certain number of resources and could direct them as appropriate, I would have greater confidence to fulfil my role than in the current circumstances for the board, where while things work very effectively, some of that is very much about the relationship between the ACCC Commission and the board members and senior staff making things work. This would provide that greater level of clarity. The ACCC, as an economy-wide regulator, works very closely with sector-specific regulators like ASIC and the ACMA and others, so we're very used to doing that in a complementary regulatory function, but we do see the benefit in the AER having its autonomy.
Okay, so apart from improving governance, to a degree, although you have confidence in the current structures. Will this improve the efficiency of the AER? In what way?
It takes away certain levels of decision-making, Senator, even though we have delegations in place so that the AER CEO, for example, has certain delegations from the ACCC chair. It just provides that greater clarity and means that decisions can be made without the need for, say, additional consultation, which might occur at the moment.
Okay, so what you're describing to me, I'm just thinking about, ordinary consumers out there, is there's a back and forth going on constantly between the ACCC and the AER, and that doesn't sound like the most efficient way for decisions to be made. So this bill will do what to that efficiency?
So the ACCC would essentially be a service provider to the AER for the IT and property functions, but apart from that, we would then have the AER would stand alone as a separate agency in its entirety, have complete accountability for its budget and other measures.
Okay, so efficient, but also more transparent.
Yes.
Okay. One of the concerns I think that the community might have if they were paying attention to this legislation would be, would it have any negative impact on the energy system and the prices or reliability, for example? Has this bill got anything to do with that?
The bill doesn't in any way change the AER's current responsibility or scope of functions.
So what does that mean?
The AER will continue to do its job. The board will continue to make the decisions they do around network pricing resets, for example, to develop the default market offer each year. None of that work changes. They'll continue to operate Energy Made Easy and do the breadth of work they're doing to support the energy transition also.
Okay, so no impact is what I'm hearing, but there's also going to be a possible positive impact.
Correct.
So in your own words, Ms Proudfoot, what are the positive impacts of passing this legislation through the Parliament?
The increased accountability and transparency, as you mentioned, for the AER board as they perform their very important role supporting the energy market and regulating.
Bringing the governance standards into 2025,
Yes.
decreasing the stickiness of decision-making between the AER and the ACCC,
Yes.
the back and forth that you described, and perhaps we could say it's a coming-of-age moment for the AER from 2005 through to 2025.
I think that's right, Senator. I mean, 20 years is a long time in energy markets, and particularly in the Australian energy market, and the changes we've seen, I think, warrant a standalone energy regulator.
Okay. Could I ask, perhaps, Chair, one final question? To be very clear, Ms Proudfoot, and Commissioner Breakey, if you want to jump in here, does this bill that we are discussing today have any implications for government energy policy?
Could you repeat that? Sorry, Senator.
Does this bill that we're discussing today have any implications for government's energy policy?
It will...
Did you say government or governance? Sorry.
Government.
Government policy.
No, I do not believe it has
Oh, that's Ms Breakey.
any implication. Yes.
Okay. And why is that, Ms Breakey?
Because the policy that sits behind the government policy and the legislative remit of the AER will remain the same. This is about the accountable authority and the kind of governance arrangements between the AER and the ACCC. It does not go to the AER's remit.
Okay, so if I hear you and reflect this in, ordinary Australian speak walking down the road, this is about changing the structure of the way the AER and the ACCC have operated over the last 20 years to bring it into 2025, to make it more efficient, and there will be no implications for government policy. Is that a fair summary?
Yes.
Thank you very much. Thank you, Chair.
Thank you.
Can I just ask just a couple of follow-up questions? I just want to ask about the your recommendation is the quick passage of the bill to allow sufficient time to operationally split the two entities in the most efficient and cost-effective manner. Is there a point at which it becomes inefficient and more costly? So, what's your idea of ideal time frame or efficient time frame or sufficient time? obviously the more time the better, I would assume, but is there a point at which it becomes unmanageable or unwieldy for the time frame that's been outlined?
Senator, I think having at least 6 months would be really helpful. There obviously is capacity for transitional arrangements should they be required, given we're currently, co-located and working together, but at least 6 months will help us set up things like the ERP system, for example, that will manage payroll. These IT projects, as you'd imagine, always need extra testing and things, particularly when they're responsible for paying people. So we want to have the time to manage that so that there can be a smooth transition with minimal impact for staff.
Right. So that ERP system, how do the ACCC support the AER to procure and build that?
So the AER currently uses our finance team and our procurement team, so they supported the procurement process. We will also need to be providing data for test runs and things like that as the system.
How long do you think the ERP will take to get up and running? Is that the 6 months? Is that what the last sticking point?
We would like at least 6 months, yes, Senator.
6 months, okay. And have the ACCC provided any advice on how many new staff are going to need to be hired to fulfil the roles of finance, human resources?
We're not looking at any new staff, Senator. A key part of this proposal was that it would not require any additional appropriation. Some of the ACCC corporate staff will transfer to the AER to support, but that's, as I mentioned earlier with Senator Smith, what we're working through currently.
And is there any advice that the ACCC is providing the AER on whether it needs to upgrade or enhance, I suppose, its governance arrangements, management of conflicts of interest, all of those sorts of things when it's not necessarily sitting under an ACCC banner?
So the AER currently does a lot of that work. They will need to set up separate things like an audit and risk committee, for example. I'll ask Ms Ayres, who's our governance expert, to provide further detail.
So the AER, in considering how they will be separated, will require, under the PGP Act, a separate audit committee. So there is a bit of a lead time to secure independent members for that, as required under the Act. The other thing to note is that the range of policies that the ACCC and AER currently have in place in relation to procurement, staff, conflict of interest, all those things are being, I guess, effectively a shift and lift into an AER setting. So there is efficiencies for that, for the General Counsel and the team there to then apply it in the new setting as a separate entity.
One of the criticisms of the proposal is that having a separate AER away from the economy-wide broad-based ACCC is the potential for regulatory capture. What is it that the new AER is doing? What safeguards is it setting up in order to prevent either that actually happening or the perception of that happening? So,
Senator, you may recall there was an audit into each of what was the financial regulators, and the AER was encapsulated in that as our agency was reviewed, and it looked into the arrangements of regulatory capture and a suite of the processes that each of the boards have in place, and they found that the policies that were being applied by the management team and overseen by the board and the commissioners demonstrated that regulatory capture was an area of focus and considered in the day-to-day operations of each of the two entities. And there was, we also have training in place for our staff, our senior executives, for the way in which they can conduct business with regulated entities. And these are matters that I understand the AER will be adopting in a separate entity scenario.
I'd add to that, Senator, things like the gifts and hospitality registers that we publish every, I think, quarter. We have a policy shared with the AER under which we don't accept gifts from any entities. Any hospitality is on a register so that it's very transparent, and it goes to that point that Ms Ayres was making regarding capture. The appointment of AER board members also will not change. That's currently undertaken in accordance with the AEMA and the government's processes for appointment, and the board members represent a diverse range of skills and experience, and I would expect that would continue, and that also helps to provide a greater diversity and lower that risk of capture.
Thanks, Jay.
Thank you. Maybe just one final one from me. We've talked a lot about the implications for the AER, but what about the ACCC? What are the implications for the ACCC as an organisation in terms of functioning and efficiency, or anything else that you might want to add in?
As I mentioned earlier, Chair, the ACCC does work quite closely with a range of sector-specific regulators as we perform our economy-wide role, and we would expect that will continue with the AER. There are provisions in the CCA for information sharing, for example, to continue. As I noted, we will be looking to realign our budget to address that proportion of the corporate spend that AER make at the moment that we won't be receiving any further, but we believe that we can manage that.
Thank you. And I do have one final question from Senator Smith. Sorry, Senator Smith, go ahead.
Thank you very much. A final question from me. The statement of expectations and the statement of intent, is that issued separately to the ACCC and to the AER, or is it delivered to the ACCC and captures the AER? Could someone just sort of illuminate that point for me?
Senator Smith, they are separate. So the ACCC has one and so does the AER.
Great. Thanks very much. Thank you.
It would continue in the future.
Great. Thank you very much.
Okay, I think that's it from everyone. Yes. Yep. Okay, thank you for appearing as witnesses today. You did take questions on notice. The committee asks that responses be provided by close of business Thursday, 14th of August. I would ask that you now, Ms Breakey, Commissioner, disconnect from the teleconference. You can continue to listen to the hearing should you wish to do so through the Parliament's website. Thank you very much.
Thank you.
I think everyone's ready. So I now welcome representatives from the Australian Energy Regulator. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
So I'm Claire Savage, I'm Chair of the Australian Energy Regulator.
Matt Garbutt, the Acting CEO of the Australian Energy Regulator.
Jeff Purvis-Smith, General Counsel at the AER.
Thank you. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Thank you, Senators. So I just acknowledge we're here on Wurundjeri lands, and I pay my respects to the Elders past, present and emerging, and thank the committee for the opportunity to make this submission. We've introduced ourselves, so I won't do that again, and obviously you're aware of the purpose of the bill. I've just heard you talking to the ACCC about it. The one thing I think it's probably really important to call out, and I hear this often, people get these things mixed up, the AER is already a separate legal entity from the ACCC. And so people talk about it as though we're not, as though it's sort of this one soup. It's not, unfortunately. We are a very separate legal entity. So the ACCC is its own entity from a corporate governance perspective. The AER is a separate legal entity that is a body corporate that has a common seal, the ability to acquire, hold and dispose of property. We can be sued and sue in our own name. etc. We are actually a portfolio agency of the Department of Climate Change, Energy, Environment and Water. And we consist of 5 full-time members who are, as I said, statutorily independent. We are responsible for a broad range of conduct and economic regulatory functions, both under the Commonwealth laws but also under state and territory laws. The challenge for us is that our program budget and our staff that are required to support our independent decision making are actually in another agency that's in another portfolio. And so what you see, and I mean, I'm a graduate of the Australian Institute of Company Directors, as probably some of you are as well. Good governance rests on clear accountabilities. And the current arrangements represent, from my perspective, unacceptable governance risks, both to the ACCC chair but also to myself as AER chair. Our independent board is accountable for the effective performance of our regulatory functions and the use of our regulatory powers to protect the Australian community and consumers. The ACCC chair, though, is accountable for the people and resources that are required to support our independent decision making. Now, this bill will correct for that and implement more efficient and more effective governance arrangements for the AER. The bill actually addresses the recommendations of 3 independent inquiries into this. So we've had Mark Vertigan did a review of governance arrangements for Australian energy markets back in 2015. We've had Alan Finkel. He did a review of the independent review into the future security of the national electricity market in 2017. Rhys Edwards did a review of the Energy Security Board that touched on this issue as well in 2020. So everyone who's ever had a very close look at this issue has come to the same conclusion, which is that the separation of the staff and the resources into the 2 separate bodies is the appropriate governance arrangements moving forward. In fact, the policy intent of this bill was actually the policy of the former government. And Senator Hume might remember that from when we've had our Senate estimates appearances together before. And it's being implemented by this current government with the support of all state and territory governments as well. So at the time the states and territories agreed to it in 2023, there were Labor, there were Liberal, there were Greens members at that point in time. So the government, this current government, did undertake a governance assessment back in 2022, which was required under the Commonwealth Governance Structures Policy, and it considered that legal separation is the preferred option against the status quo. And the bill is very minimal in scope, so it is literally just going to bring us into line with other standalone independent regulators. And we as an agency, and by that I mean in practice, so the AER does already practically operate as though we are separate, so we are ready to implement this bill and the timely passage of the bill, and we can facilitate, I think, effective and efficient completion of all the work that's necessary to bring us into line for a separation date of 1 July 2026. So I'll pause there and turn over to questions from the senators. Thank you.
Thank you. Dean? Yes. Sorry, Senator Smith.
Thank you very much. Thank you, witnesses, for your participation. In the Finkel review, where the matter of structural separation was considered, the review made the point, and I'm quoting from the review now, the review said that the structure, governance and funding arrangements of the AER are a long-standing concern for key stakeholders, and a decision on structural separation should be resolved, but not without clarity on a sustainable funding agreement. Noting that the Finkel review was in 2017, I'm just wondering whether you can just share with the committee whether that qualification around the need for clarity on a sustainable funding arrangement has been achieved or has been reached from the AER's perspective?
Thank you, Senator, for the question. So I think following 2017, and I'll have to ask my colleagues just to check the details of this because I became chair in 2019, but there was a review that was undertaken in 2018, I think, from memory, Senator, which looked at the funding levels of the AER, and there was an uplift around that time. It might have been in the 2019-20 budget, but I'll need someone to clarify that for me, Senator. Since that time, the AER's continued to get additional functions. I mean, we're in the middle of probably the fastest transitioning sector in the Australian economy. So the functions and responsibilities of the AER have changed and grown since 2019, and so there have been additional funding provided to the AER through that period of time. We still have, I wouldn't say that we have everything we need, Senator, but I think we certainly are in a position where we can discharge the functions that we need to do. But it is obviously a challenging time for many agencies in terms of meeting a growing set of responsibilities.
The challenging set of responsibilities being faced by the AER that is separate and independent to any sort of demand or demand increases that might arise from this separation?
That's right, Senator. So I'm referring more to new functions, like, for example, we've got a rollout of smart meters happening, and so there's additional compliance and enforcement work the AER needs to do from that perspective. So the sorts of challenges I'm talking about have nothing to do with the matters before us in this bill. In fact, at the moment, the AER program budget allocates around $20 million a year to the ACCC for our shared services, and we can fund, we believe, our separate governance arrangements and requirements, our corporate functions, within that funding envelope.
Thanks very much. What costs have already been incurred in the preparatory work for the separation by the AER?
So I'll have to ask to come back on notice for the exact specifics. I did hear you ask the ACCC this earlier. Essentially, the costs to date have really been the engagement on the ERP program that you were just discussing. So that's the finance and HR program. We have said to government in the submissions to date on this that we would be funding any one-off costs out of our balance sheet. So we're not intending to ask government for any new money to fund legal separation, and the ongoing costs can be funded within our existing funding envelope.
Thank you very much. What will the total cost to the AER? What is the total cost to the AER of the sharing of property and ICT services from the ACCC?
On an ongoing basis?
Yes, please, yeah. Yeah,
that's still being negotiated, Senator, via our agreements for shared services agreements. So at the moment, we don't actually have service level agreements for that $20 million that we do provide to the ACCC each year. But as part of separation, we're negotiating those. So there is a property agreement and an ICT agreement as part of that. But I'll just ask our General Counsel whether we have specific numbers on that yet.
No, we don't. We're still going through basically the service level standards and the suite of services that would be provided, because it gets into some detail, for example, shared library services and the purchase of books and online resources and so on. So we'll go through with fine detail in relation to what we will pay for ourselves and what we'll receive from the ACCC.
Currently, though, Senator, we pay, I think, 25% of the property charges for the ACCC. The AER does.
Okay. In the Vertican review, it said that establishing the AER as a standalone body would encourage it to adopt a culture that vigorously pursues and promotes information discovery and adapts and adjusts to the new challenges that are being set for the energy sector. Is that statement, again, recognised that the Vertican review was back in 2015, is that statement still a true statement? And can you point to cultural traits that demonstrate the panel's view about the positive impact on culture at the AER?
You were just cutting a little bit in and out there, Senator, but I think I understand the nature of the question. So, look, Mr. Vertigan did make that, or Dr. Vertigan made that comment quite some time ago, and I would have to go back and look at the surrounding context on that. I have been chair of the AER for nearly 6 years now. I would say we have a very strong culture around both our enforcement of the energy laws and rules, but also information collection, disclosure, transparency, etc., or information sharing with other appropriate agencies. So I'm not sure whether or not that is going to specifically be addressed in the separation bill, because I'd have to go back and look at what Dr. Vertigan was specifically referring to.
Okay, yes, that's a direct quote from the Vertican review. Is it is it necessary, or can the AER demonstrate any direct benefits to energy consumers that arise from the separation?
I think that the benefits that arise from separation are numerous, to be honest. I mean, one of them is good governance, right? And I think every consumer and every Australian is interested in good governance of federal agencies. And this bill absolutely supports good governance and appropriate accountability and appropriate independence. And so from that perspective, I think that's a plus, and that's something we should all hope to achieve. In terms of the more direct benefits, I think it is a more efficient set of governance arrangements. So if I give you just kind of examples from my lived experience in the last 6 years. So myself and my Deputy Chair, Justin Oliver, are both members of the ACCC's Corporate Governance Board. And so we sit on that board to provide oversight not just to the ACCC but also to the AER. But the AER is technically a division of the ACCC, which divisions are not normally 450 people. And so it is not sufficient really to govern the AER as an agency via the Corporate Governance Board. And so the AER board, because we ultimately, if something goes wrong with the decision-making of the AER, or if there is a significant failure in our decision-making, that responsibility and accountability will rest first and foremostly with me as chair of the AER and with our board collectively, not with the ACCC. But the responsibility for the people and the money will sit with Jenica Scott-Lieb as chair of the ACCC. And so from my perspective, I'm trying to make sure that, and my board is trying to make sure that we do have sufficient oversight of our people and our resources, even though we don't have legal responsibility for our people and our resources. And so we have our own governance arrangements. So we have a monthly governance forum that we've established. We have our own processes, our own papers that come to that. We have oversight of budget, risk, enterprise risk management framework, audit processes. I mean, everything for us is now duplicated because we're trying to participate both in the ACCC's governance arrangements but also have sort of a shadow set of governance arrangements ourselves to provide us with appropriate level of satisfaction. Because, at the end of the day, I have to put my signature next to Gina's on things like fraud policies for the whole agency. Therefore, I need to remain across all of that for the whole agency. So I think there's a lot of efficiency that comes both for the ACCC and the AER in ensuring this separation occurs, and will help us to focus on the job that you've employed us to do, which is to regulate the energy market. And I think that will be for the betterment of energy consumers.
Great, thank you very much. I may have one or two. Just to confirm, the statement of expectations will continue to come to the AER in the normal way, and you will continue to provide a statement of intent to government in the normal way. That nothing around that accountability mechanism changes.
No, you're absolutely right, Senator. So at the moment we receive a statement of expectations that is signed off by the Commonwealth Minister but in agreement with all the state and territory energy ministers as well. And then we respond with a statement of intent to that. That will continue to be the case. As I said in my opening comments, because the AER is actually a DQ portfolio agency, we get kind of confused sometimes because we actually turn up to the Communications and Environment Senate Estimates Committee, but our people are part of obviously the Treasury portfolio, so it all gets quite confused, I think, the way it is right now, because we have got not just the problem of being legally separate but without control of people and resources, but we're legally separate and in a separate portfolio agency to our people and our resources. So this bill will actually bring all of that into a streamlined
productivity of the Senate.
Yes.
Is savage. That's no small accomplishment.
And a confused accountability to the Parliament is what you're saying as well.
That's right. So when we get questioned on our budget estimates, for example, it's actually in the wrong committee, technically, because our program budget is in the Treasury portfolio, but the agency is in the DQ portfolio. So the board gets questioned via the DQ portfolio, but the estimates are actually in the Treasury portfolio. So yes, it will hopefully, I think, improve the governance from that perspective as well. So parliamentary accountability will be improved.
The scrutiny might be more effective.
I hope so.
Thank you very much. Thank you, Mr. Chair.
Thanks. Senator O'Neill.
Thank you very much, Chair. And can I commence just with that last point, parliamentary accountability? I think when you make that point, it becomes very clear that in the period from 2005 and establishment to 2025, we are in a very, very different place. And that what we're really doing with this bill is a sort of housekeeping, if you will, to make sure that the 2025 reality is matched by an appropriate governance structure, an appropriate transparency structure. And you've made the case here today, Ms Savage, that there are significant efficiency gains. The nation is talking about a productivity agenda. I was a little shocked, excuse me, by your language, and I think this really put a point on why this legislation should proceed, is that there is a shadow set of governance procedures that you spoke about. So if you could just fill out that so we understand what is inefficient about the way it's currently structured.
Yeah, and I think it's probably a little bit of history is helpful here too, because it has been 20 years since the AER. We just had our 20th birthday, actually.
Happy birthday.
Thank you. Now, a little bit of, I guess, a confession from me. I originally was in the Treasury in 2005, 2004 and 2003, but before then, and I was involved in establishing the AER. And it was the very strong view of the ACCC at the time that the AER was to be a constituent part of the ACCC. But that was because at the time it was literally a shifting of the regulation of electricity transmission assets from the ACCC into the AER. But since that time, the AER has picked up the regulation of state and territory distribution assets, which was previously done at a state and territory level. There's been the creation of the National Electricity Law, the National Gas Law, the National Energy Retail Law, the rules that support that. There's something like 12,000 obligations, unfortunately, that sit across all of those instruments. That would be a productivity gain if we could, I think, rationalise some of those. But there is a huge volume of responsibilities and obligations that the AER is in charge of monitoring and enforcing compliance with. And the functions of the AER are vastly different to what they were back in 2005. So the 2005, it was this little electricity branch of the ACCC that kind of dawdled along and did its thing. Now it is, you know, as I said, 400 and something people doing compliance and enforcement, monitoring competitive markets, collecting spot market information. We are now one of the Commonwealth's largest data holders. So the ACCC isn't. Like, we have the needs. We have a spot market that settles every 5 minutes, and with algorithmic bidding, we ingest 50 million bids a day. So our IT needs are complex. They're very different to that of the Commission. So from an efficiency perspective, there are so many things that are different about our agency to the broader sort of whole of economy regulator that the ACCC does a fantastic job of, that an industry-specific regulator needs to meet its functions and needs in a very specific way. So I think, you know, I have countless examples of the sorts of efficiencies that can be generated from it. You know, our chief executive is a band 3. SES Band 3, the ACCC's chief executive is an SES Band 3. Our chief executive can't sign off on part-time working arrangements for their SES officers without the approval of the ACCC CEO.
So which is probably an appropriate situation if you were still a toddler at the 2005 version. But the adult at 2025 that the AER now is only limited and inefficient by such practices and procedures continuing.
Yeah, and we are 5 full-time members with significant experience. I mean, I have worked in this energy sector for more than 20 years myself. We are not children. We are adults, and we're perfectly capable of governing our own agency. And so from that perspective, and I would argue the AER board has always been perfectly capable of governing its own agency. There was a decision at the time as a compromise between various actors to sort of set it up the way it was. But, you know, even from 2015 when Mike Vertigan did his review, so 10 years ago, people were saying this is a change that needs to happen, and it becomes more pressing as we go on.
So from 2015, the Vertigan review, Finkel review 2017-2020, Edwards, which I know were under the previous government, which supported this structural separation to align with your separate legal entity reality. You indicated in your opening statements that it's also supported by all the states and territories.
That's correct.
How did you go about acquiring that support, and how strong is it?
So the government, as part of the Australian Energy Market Agreement, had to consult with the state and territory governments, and so each of the state and territory governments were consulted in 2023 and provided their support. Now, they didn't want to see any change to our functions and the way in which we're appointed, and there are no changes to that via this bill, but they supported legal separation of the AER and the ACCC, and always have. So the states and territories have always been of the view that we should be legally separate.
So the ACCC supports it, strongly supports it, in fact, based on their evidence this morning. Every state and territory supports this piece of legislation and the separation that we've been discussing. Ms Savage, you seem to support it too.
Very strongly, Senator.
I think there was a practical concern raised by my colleagues from the other side of the chamber about the timing of this, and I think you indicated 1 July 2026. Or the ACCC indicated 1 July 2026 would be the date that it would come into being. They also indicated a respectful approach to the Parliament, that the work that has been done is preliminary. I think Mr Purvis, I can't see your surname,
Purvis Smith.
You indicated that negotiations are underway with regard to property and IT, and in fact down to a line-by-line discussion. All of that is on hold until the Parliament actually passes this piece of legislation for you to proceed. If that were to be the case and Parliament passed this, are you totally confident that the preliminary work you've done will allow you to get the job done without any disruption?
So this is essentially for us a machinery of government change. So we've been putting this in place over the last financial year with the expectation that the previous bill was to come into effect from 1 July 2025. And so we had commenced the ERP process, we'd gone out and procured that. The work has been, it's not on hold, but it's happening, at a reasonable pace, a respectful pace, in the sense we're not getting ahead of ourselves and assuming passage, but we are making the necessary preparations in the event that passage would occur. And so when the Parliament lapsed and the bill lapsed and needed to be redone, 1 July 2026 was the date that we asked for at that point in time, to give us sufficient time, the Parliament sufficient time to consider it and to hopefully pass it, and then us sufficient time to make sure we could complete the necessary arrangements for separation.
Thank you. You've indicated the benefits of good governance that will occur, the efficiency of not having a shadow set of governance procedures, and the inappropriateness of having a division of 450 people sitting under the ACCC, which is not common practice, and in fact at odds with best practice, I think, from what you've said. What are the benefits to the Australian people? The concern for everybody is, this change, has it got anything to do with real people out there? Will there be any negative impact on the energy system from this kind of a governance change? Will there be any impact on prices or reliability? Has this got anything to do with that?
So it has nothing to do with our roles and our functions and our responsibilities. So the decisions that we take and that we're discharged with taking will be the same before and after separation, and we'll approach them in largely the same way. Why I say largely is I think our own internal functioning will be more efficient, and so from that perspective we'll probably have greater capacity to turn our minds to the job that we have to do, but it's at the margin. It's not sort of the bulk of what we're focused on.
Okay. So
it's marginal improvement.
Positive impacts of a marginal nature. So separate is this from what's actually going on in terms of the energy market?
Yes, that's
This is simply housekeeping for good governance, fulfilling recommendations of 3 government reports undertaken in the previous government, follow-up reports in terms of governance assessments in 2022, a consultation with every state and territory in 2023. This is get on with the job, clean up house, and let the AER do the best job that they can, transparently and accountably to the Australian people. Is that a fair summary of where we are?
It's a wonderful summary. Thank you, Senator.
Thank you very much. Thanks, Chair.
Chair, I've just got a couple of questions. I think that we all agree that this is a housekeeping exercise, and we all love hospital corners on our regulators and legislation. I just want to ask a little bit further on Senator O'Neill's questions. Is there any intention to have, or is there capability for a measurable consumer outcome from this?
It comes from greater efficiency within the AER, really. So given that the decision-making, the nature of the decisions don't change because the functions and the roles and the responsibilities don't change, but to the extent that we remove duplication and we have greater opportunity and time within our our any given week to turn our attentions to the matters that you would hope we would be focusing on, which is the Australian people and energy consumers, we will have more. We'll be more efficient in doing that, and we'll be able to focus more on that. But that's why I say it's a marginal improvement.
Right, it's not something. It's not measurable.
Is it measurable? No, I don't think it's probably measurable.
That's okay. That's okay. I just wanted to be clear on that one. And look, you said something at the beginning which I thought was very interesting, and I'm wondering whether you can unpack a little bit more, which was, and I understand that the sort of streamlined administration, much better decision making, all of that, that's fine. But you said that the current arrangements have unacceptable governance risks. Risk of what?
So I think the risk is from my perspective, so I've taken on the role of chair. I come in every day, I do my best, but I very much depend upon, obviously, the papers we receive, the advice we get, the documents that are put together for us, the consultants that are engaged to support our decision making. But we don't control any of that. And so from the perspective of governance, we are accountable for the decisions, but we can't control directly how the advice that we receive or the support we get to make those decisions is done. Not the culture, not the hiring practices, not the way in which they are themselves held accountable. And so from that perspective, that's an unacceptable governance risk to me. From Gina's perspective, and I don't want to put words in her mouth, but from the chair of the ACCC's perspective, she is accountable for the people and the money and how it's all discharged within the AER. But in practice, it's directed by us. And so for both of us, it represents an unacceptable governance risk because we're both sort of accountable, but not for the things that we, would make sense from a line responsibility perspective.
Okay, thanks.
That's all. Very different views on hospital corners. Senators.
You love a hospital corner.
Feels to me like an unbanked bed. I can see why it's a hospital corner for you, though.
Thanks, Chair.
Senator Walker.
Thank you, and thank you for making the time to be here today. You've spoken extensively about the importance of efficiency and good governance. My question is, do you perceive this bill having any implications on the government's energy policy? You've spoken about what it's going to mean for you internally and how your organisation's going to run, but what about government energy policy? Do you see there being any implications for that?
No, the government's energy policy is given effect to via either it's the industry code within the Competition and Consumer Act or via the National Electricity Law and Rules and the National Gas Law and Rules and the National Energy Retail Law and Rules, which is done through cooperative legislation with the states and territories. None of those things change from this bill. So the job that we've been given to do remains exactly the same. This just fixes our hospital corners.
Just my second question. Can you confirm that the legal separation from the ACCC has been subject to other review processes, for example, public consultation? And further from that, are you aware of anyone opposing legal separation? And if so, why do you think they've taken that position?
So it has been subject to other reviews. So the Vertican review in 2015, I can't remember if that had public consultation, but the Finkel review in 2017, which did have public consultation, the Rees-Edwards review in 2020, I can't remember whether that had public consultation or not, but the Finkel one certainly did. And then it has had the 2022 governance review by the Department of Finance. There's been consultation across the departments across Commonwealth Government. So there's been quite a bit of process that's gone into this consideration. I am not aware. I did see that there was one anonymous submission that came to this inquiry that did not support separation, but I don't know who that is, obviously, so I don't quite understand what's driving that. There also looks like there's an anonymous one that supports it, but I'm not sure who that is either. So other than that one submission, I'm not aware of anyone else who would have a strong view on this to be opposed to it.
Senator Smith, do you have any other questions?
Just one last question from me. Is it correct to describe the current arrangements as suboptimal when we think about the public governance performance and accountability regime?
I think they are suboptimal, yes, Senator. Yeah. And they're workable, and I would say the ACCC and the AER ensure that they're workable, but they are suboptimal.
And I could not find any commentary about the suboptimality, if that's a word.
It is now.
In the context of the PGPA Act regime and these arrangements, but given the emphasis that was put on rolling out the new PGPA regime all those years ago, it does seem like an anomaly in terms of how this arrangement worked in the context of that regime.
That's right. And there have been some changes. I mean, you'd note that this bill will have the AER as a whole, so the 5-person board will become the accountable authority for the purposes of the PGPA Act, whereas the ACCC is currently constituted under the sort of the older way of doing it, which is with the chair as the accountable authority under the PGPA Act. So some of these changes are obviously happening as, the recommendations are being implemented as changes occur. So that was something the Department of Finance felt would bring it into a more modern governance structure for us, was to have the full board as the accountable authority under the PGPA Act, but me, or the AER chair, as the accountable authority for the purposes of the Public Service Act.
Great, thanks very much.
Thank you. Just one final question from me. I'm not sure if you heard, there was a question to the ACCC about industry capture. Just wondered what your view was on any risks around that, whether you heard that response from the ACCC and anything that you wanted to add, or what the AER has been thinking about this.
No, thank you, Senator. I think that's a great question. We are already, as I said, because we're already legally separate and a legally separate entity, we already have to manage that issue. And so if you were to look at the AER's enterprise risk management framework, we have industry capture as one of the risks that we manage there. It's done through a variety of ways. I mean, obviously our appointment processes, etc., are a key way of doing that. But the Gifts and Hospitality Register, the conflict of interest arrangements, we're all subject to the Public Service Code of Conduct. You know, there's a range of different elements that protect and guard against industry capture. But I'd also say our track record speaks to that. So if you had a look at our compliance and enforcement track record over the last 5 years, we've collected more than $100 million in penalties. I think in the last year alone, it's 50-something million. So, 53 million, Matt will tell me, because he was the Executive General Manager of Compliance and Enforcement before assuming the acting role. And so, we have a very strong posture in line with the Hayne Royal Commission. We absolutely are very focused on protecting consumers and ensuring that consumers are protected. It's the number one pillar in our corporate strategy. And so I think we have all the processes and systems in place you'd expect to guard against industry capture. But in addition to that, our intention is to pick up the existing, by and large, policies of the ACCC as we merge across, and then they would only be, adjusted through time for the specifics of the industry. But things like gifts and hospitality and conflicts of interest, they're all going to be exactly the same. Yeah.
Thank you. Yeah. All right, we're good. So thank you for appearing as witnesses today.
I was excited to do it.
Yeah. If you took any questions on notice, the committee asks that you provide responses by close of business Thursday, 14th of August 2025. And you can continue to participate in the hearing as an observer if you wish. Otherwise, you're now free to go. Thank you.
Thanks very much, Senators, for the opportunity.
Okay, I now welcome representatives from the Department of Climate Change, Energy, the Environment and Water. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Linda McGrath, Head of Division, National Energy Transformation Division, Department of Climate Change, Energy, Environment and Water.
Matthew Minchin, Branch Head, National Climate and Energy Partnerships Branch.
Thank you. Do you have a short opening statement that you would like to make?
No, we don't.
Okay, well, we will go straight to questions. Senator Smith is going to go first.
Thank you very much, and thank you, officials, for being available this morning. To confirm, the department doesn't expect any future budgetary increases or resourcing increases from the AER as a result of this separation?
That's correct. It will be done within existing resources.
And the government and the department is unaware of any expected future resourcing demands that might be requested from the AER?
With respect to the separation, no, we're not.
Are there expected resourcing demands for the AER separate to this separation that the government is aware of or expecting?
Not that I'm aware of.
Sorry.
With their heads.
Sorry, I said not that I'm aware of.
To what extent is the department kept abreast of the various discussions that are happening between the ACCC and the AER to give effect to separation?
So we have regular contact with our colleagues in the AER, and there's a good amount of communication between the between the agency and the department on these.
And to what extent does the department? So, to what extent does the department just? So, is the relationship just one of the AER informing the department of progress, or is the department more actively engaged in discussions between the AER and ACCC?
I couldn't hear that question.
Yes, thank you, Senator. The primary engagement we have is directly with the AER in line with the oversight that the department has. But we do engage with ACCC, and ACCC does participate in some of the national energy processes as well.
How does the department expect Australian energy consumers to benefit from the structural separation?
So, as previous evidence stated, that this is a governance change, so the roles and responsibilities will become much clearer for the board and as a result of the change. It'll reduce internal red tape, and so to the extent that then frees up the staff to focus on their purpose, that will deliver benefits for consumers.
Can the department share with the committee what other alternatives might have been originally considered prior to the separation solution being adopted?
Thanks, Senator. As your earlier question noted, the Vertigan Review considered a number of different options in forming its recommendation. Essentially, there were three options that they considered. One was greater internal separation. One was a standalone AER, and then a third was part of a new competition regulator, but they didn't go into that option in great detail. Effectively, it was recognised that greater internal separation, though noting the answers from the earlier witnesses, it's significant internal separation as it stands, but maintaining that approach perpetuates the governance risk and also doesn't address the cultural difference that the Vertigan Review considered as well, the difference between a broader competition law enforcement organisation like the ACCC and an industry-specific regulator. The Vertigan Review, in addition to those three options, did make a number of other recommendations relating to the AER, things like increasing the board size from 3 to 5 members, which was adopted.
Did the Vertigan Review provide any caveat or qualification to the structural separation option?
Sorry, Senator, I missed.
Did the Vertigan Review provide any qualification or caveat when considering the suitability of the structural separation option?
The Vertigan Review did note that the separation does result in you lose the ability for some synergies when you're operating within a single larger organisation, but it recognised that the role, as I said, of an industry-specific regulator was quite different to a broader economy-wide competition law enforcement, and so it noted that while those synergies were lost, the gains from having the full control of resources and the independence outweighed those downsides.
Okay. That's enough from me just for the moment. Thank you.
Thank you. Senator Walker.
Thank you, and thank you for making the time to be here today. My first question, do you support the passage of this bill? And if you do, would you mind expanding on why?
Sure. Yes, the department does support the passage of the bill because it does make sure roles and responsibilities are clear. It recognises the growth in the AER since it was first established and makes sure that the board is accountable for both the regulatory function and the people and resources, which is in line with good governance arrangements under the PGPA Act.
So we've heard a lot today about the importance of good governance. In your view, do you think this bill will improve the governance of our electricity system?
Well, it certainly improves the governance of the AER in the sense that the board becomes the accountable authority, so yes.
My next question, do you perceive that the passage of this bill will have any negative impact on the energy system, such as prices or reliability, for example?
Any negative impact, did you say? No.
Do you think there could be a positive impact, and if so, what do you think that would look like?
As we said previously, it allows we've heard evidence that there's some duplication of effort within the AER at the moment because of the current arrangements. So by removing that internal administrative burden, it frees up resources to focus on the role of the regulator.
I might ask a couple of follow-ups, if that's okay. I think we've heard from the previous witnesses that their view is that this bill doesn't have any impact on government's energy policy. Would that be your view as well?
Yes.
Yeah.
Yes, and it's solely about governance.
Yeah. And do you think it will have any impact on the policy freedom or options of future governments? Or this really is just simply an administrative...
It's simply an administrative governance matter, yes.
Yeah. And we've also just, just to kind of round out the question about industry capture. Has the department had a look at this question, and do you think that this bill proposes any risks in terms of industry capture outside of what is already there and the current arrangements that are in place and what we've heard from the previous witnesses about how they're addressing that?
I would refer to the evidence provided by previous witnesses. I would also note that the Vertican Review did also, in recommending the standalone AER, note that industry capture had been flagged as a potential risk, but had also gone on to highlight that there was, through that significant review process, no evidence of industry capture at the time, and noted that all the checks and balances were in place as part of the broader energy structure within Australia, and actually were leading practice. So combine that with the evidence provided by Ms Savage, I think shows that there are appropriate checks and balances there.
Thank you. Senator Hume?
Just very briefly, is there any benefit for the department itself having this change made?
Not that I can think of. It's quite negligible, other than the evidence that's been presented about the challenges with the regulator sitting within our portfolio, the budget, and people sitting within the Treasury portfolio. So the extent that now moves over into our portfolio, the AER would now be, their finances will be part of our portfolio budget submissions. So I guess there's that minor portfolio budget statement rather. So there's that minor change from the department's perspective, but really at the margins.
I was fascinated to hear Ms Savage's evidence that the AER was one of the Commonwealth's largest data holders or data collators. And I just want to understand whether that is something that either the department has access to now, or would get access to, or could use in policy development because of this change.
I don't think it would change our ability to access information. I can't.
Do you access it now?
I think I'd have to take that on
We'd
notice.
have to
It may well be we're part of a large group of, in terms of energy group. I'm sure there are some that may approach the AER about data. I'm not, but we're not aware yet.
But I would note that as an independent regulator, there are checks and balances there too in terms of accessing data. So we can take that in notice.
Okay. Thanks.
Thanks, Chair. Thank you. Yes, one. Senator O'Neill.
It's always a mouthful to say the Department of Climate Change, Energy, the Environment and Water, and everybody shortens it down to Q.
Yeah.
It's great to be part of a federation as a nation. One of the things I think is important in the evidence we've received is the support of every state and territory. Having the states and territories on board, how advantageous is that to you in your interactions across the nation?
For this particular bill, Senator, I think it's beyond advantageous. It's a requirement of the Australian Energy Market Agreement that the ministers across the country support a change to energy law or energy structure in that respect. So it is certainly advantageous, but it's essential.
So it's a very significant agreement that has already been reached by every state and territory.
Yes.
That this legislation would then bring into being, having had already acquired that consent from all our partners across the country.
That's correct.
Ms McGrath?
Just to confirm, that's correct, yes. And I think there was mention earlier as well about the statement of expectations, and just to clarify as well that is also set by the Energy and Climate Change Ministers.
Okay. You indicated in your response to a question from Senator Hume that there would be no particular change for you in many ways, but the issue of accountability in the Senate has been raised here. What does this, if the legislation is passed and we move to this new structure agreed with the states, what does it mean for Senate estimates and potential efficiency gains there?
Well, it does mean, as was previously said, that with the AER attending estimates alongside DQ, that also their any matters relating to their resources also sit within our portfolio rather than within the Treasury portfolio.
Aligning with your energy in the middle DQ.
Exactly.
Yes. Yes. Thank you very much. Thanks, Chair.
Thank you. Any final questions? No. Senator Smith is good.
Chair, just one from me, if I may. Senator
Yep.
Smith. The department might care to take this on notice. I'm just keen to understand how the Public Governance Performance and Accountability Act, which currently sits across the Commonwealth, views the existing AER ACCC arrangement. I've not been able to identify any commentary across the government about the suitability or lack of suitability of the existing arrangements in the context of the PGPA Act, and I was wondering if the department might just take that on notice for the committee.
We can do. It does. Our Department of Finance colleagues probably be better placed if you want a specific answer around the PGPA Act. But what I would say is that they have been consulted on this change and absolutely aligns with the PGPA Act, and also takes into account the significant growth in the size of the AER since it was first established.
I don't doubt that the prospective change, the structural separation of the AER from the ACCC, would meet the PGPA Act. That's not in question. I'm keen to understand to what extent the existing arrangement, the arrangement that currently exists, might in actual fact run foul of the PGPA Act regime. But if you could take that on notice, that would be much appreciated.
We can do that.
Thank you.
Okay, thank you. Thank you for appearing as witnesses today. Any questions on notice that you've taken, the committee asks that responses be provided by close of business Thursday, 14th of August 2025. And that concludes today's hearing. So thanks to all of the witnesses who appeared, Hansard and Broadcasting for your assistance, and the committee stands adjourned.
Can hear you well, yep.
Great. All right, we'll kick off then. I declare open this hearing of the Senate Economics Legislation Committee into the Pacific Banking Guarantee Bill 2025. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via teleconference and in person. If witnesses are remote, we have just Senator Smith on the line, participating remotely so far. These are public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I would now like to welcome Mr Francis Yorn, representing the Australian Fiji Business Council, the Australian Pacific Island Business Council and the Australian Papua New Guinea Business Council. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committee has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Chair. My name is Francis Alric Yorn, Y-O-U-R-N, and I'm Executive Director of the Australia Fiji Business Council, the Australia Papua New Guinea Business Council and the Australia Pacific Islands Business Council, and that's a mouthful.
Thank you, and I would just also note that we have Senator Collins joining us on teleconference as well. I invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Senator. Look, we're really grateful as business councils to have the opportunity to come and meet with you today. We think that this is an important piece of legislation to support Australian business operating in the Pacific. It's a natural follow-on from the Pacific Banking Conference, which was held in Brisbane in August, I think it was, or September last year, which was supported by the Australian government and the US government and focused on particularly around issues like correspondent banking, but a whole range of other issues for the banking sector as well. For business to operate effectively in the Pacific, it needs a strong, well-organised and reliable banking sector. Australian business does hundreds of millions of dollars worth of business in the Pacific, in trade, in goods and in services, particularly around infrastructure development. And most of that funding for that comes from donor governments and multilateral donor agencies. And all of it needs to go through banking systems that are reliable somewhere in the Pacific or based out of Australia. The presence of Australian banks in the Pacific is critical for Australian business to operate confidently there. And Australian business operating in the Pacific is a critical part of the whole of Australian government presence there as well. We think that it's important that this legislation goes through to give business confidence that the banks are going to be there in the long run to support business. So I'll just leave it at that, Senator. Senators got access to the statement that the Business Council's made last week, and I'm happy to take questions.
Thank you. Senator Hume? Yes. Thank you, Chair. And thank you, Mr Yuan. I want to just preface this by saying that the Coalition very much understands that the guarantees are designed to keep those banking services open across the Pacific, and that's something that we wholeheartedly agree with. This is more about making sure that we're getting the details right. So I want to ask you from your members' perspective, that ANZ guarantee, is that alone enough to address the debanking challenges that you're seeing or other challenges that you're seeing in the banking sector, or do you think that additional measures will be needed?
I would say additional measures are needed in the shape of the legislation that's there, which provides wider support than just that arrangement that the government has entered into with ANZ.
So what specifically would you recommend?
In particular, just making sure that all the banks that operate in the Pacific have access to good financial services, especially around correspondent banking arrangements. So, I mean, that arrangement with ANZ was the first arrangement that was being made with a bank, I think, to operate in the Pacific. The Commonwealth has now entered into an arrangement with the Commonwealth Bank of Australia to operate in Nauru, which is very important, I think, because Nauru is not a particularly attractive operating environment, and so Bendigo Bank, I think, did a good job in being the first bank in there for some time, but they obviously couldn't sustain that, and so it's good that the Australian government has assisted the Commonwealth Bank. I don't know the terms of that assistance. But I just think that we need to have a good, strong legislative framework, and one-off contracts are good, but we need to have something that's more sustainable in the long run.
So how much do you think is an appropriate amount to be allocated to address this issue?
Are you talking about in the
dollars
in the Commonwealth budget? Yeah, look, I wouldn't put a number on it, because the reason is that exposure can grow. You know, as Australian interests in the Pacific increase, and Australian business in the Pacific increases, which we hope will happen, the value that you would have to put on it could grow.
So what if there, for instance, was a cap on the guarantees? Now, at the moment, we know that the ANZ's program is a $2 billion one. What if if we multiplied that by 5 and said that there were 5 of those and it was a $10 billion cap? Is that too much of a limitation, do you think, on the support that would be required?
I'm really not in a position to talk about the technical aspects of that, but I know that's a nice number. But I think that it comes down to what the need is to retain the financial services system operating effectively in the region.
Well, I think recognising that there is support across the Parliament, certainly across the two parties of government, that this is a good thing in theory. Putting a cap potentially on the amount is a safeguard in itself, is it not? Knowing that it can be changed and it can be flexible because there is support for the initiative across the
and I was going to say a cap is something that you see at a point in time, but caps always anything that's legislated can be changed. So it could be something that starts with a cap but evolves.
Can I ask the organisations that you represent?
Clarify that.
Sure.
I think it's a very good question. Much of this support that's being given is as much as is necessary and no more than is necessary, and of course much of it will be done in private because there are commercial in confidence concerns. While I understand the sentiment of the question from Senator Hume, the question for me remains, is declaring a number a point at which, in public, a point that can be gamed? Are there unintended consequences of making such sensitive amounts public? Not that they shouldn't be known, in the government, but in the public place. We deal with commercial in confidence matters through the Economics Committee and the Corporations Financial Services Committee all of the time. So my question is genuinely, could public knowledge end up with such a system becoming gamed?
There's always the potential for unintended consequences, and that could happen if it doesn't have the right sort of regulatory framework around it, I guess. I mean, a lot of these things do operate in good faith, but sometimes where dollars are concerned, good faith comes second. So I don't have an answer to that question other than really to say there needs to be enough flexibility in the system to make sure that it's managed effectively, and that the people who are responsible for managing any cap that's put in place understand when it looks like it's being gamed and are able to investigate that.
Thank you, Chair. Thank you, Senator Hume.
That's a pleasure. Can I just ask, one of the criticisms has been about how Australian banks could potentially crowd out local banks, and that having this guarantee puts Australian banks and local banks on an uneven playing field. Do you have any comments on that? And what is your experience, what was your organisation's experience with those local banks?
Well, I think perhaps I'll take the first part of that question first. I don't see any evidence that Australian banks would be looking to do that. I'm not inside the Australian banks, but frankly, I don't think that that's the sort of business that they're looking to do in the Pacific. It's profitable if you play the game right in the Pacific. Historically, it's been quite a profitable.
Why are they leaving then?
I think it's to do with risk. The risk element has become greater in recent years than perhaps it was 20 years ago. But they can tell you why they're leaving. It's not up for me to put words into their mouths. On the second point, sorry, can you just give me the second point again?
Yes, the second point was your experience with local banks as opposed to Australian banks.
I was going to say, yeah, that in most jurisdictions, there's not many local banks. They're very small. I mean, PNG and Fiji, you could say, have a stronger banking system than any of the other countries. So the Australian banks and also, the PNG bank that's in 5 markets, I think it is, they're important to the operation of those countries' economies. But, it's a small banking market compared to Australia.
Can I just, I've only got a couple more questions, Chair. I realise there's a queue. But I wanted to ask you about when each of your business councils became aware of that ANZ bank guarantee, and whether your business councils were consulted as part of the development of the guarantee.
The business councils weren't consulted.
They weren't?
No. And I don't know what the process was that was gone through to reach that conclusion. I know it took a long time because I heard the Treasurer announce it probably a year ago or no longer. But no, we weren't consulted about it, and I don't think we had any expectation that we would be. It was a commercial in confidence arrangement between the government and a bank. And at that time, people were uncertain about what the commitment was for Australian banks to remain in the region. So the response from business generally was, well, if that means that ANZ is going to stay in the region, that's a positive. And so this legislation sort of broadens that out.
Just finally, Chair, in your understanding, does the guarantee mean that the services that your councils need will be provided for?
Well, we believe it increases the chances that in the longer run that the availability of those services will remain.
Right.
And that's what we want.
So you have the services you need now. This guarantee will secure those services. Is there more that your business councils are looking for that you would expect this guarantee would cover?
I think individual businesses will have different objectives that they want. So we haven't discussed what more we would want beyond just wanting to make sure that the banking system in the Pacific remains stable and secure for Australian business to operate.
Okay.
Thank you.
Question on that line, if I can. You just responded to Senator Hume by indicating there was no consultation before the announcement. Would it be fair to say that your views about the need for stability in the banking system across the Pacific were already well known in the public place?
I think they probably were, yeah. Yeah, I think that's a fair comment.
Thank you.
That's good. Thanks, Chair.
Thank you. Senator Walker?
Thank you, and thank you for being here today. Just to remark on what you said earlier about the importance of a strong banking system to support business in the Pacific. Would you mind sort of expanding on how Australian banks support Australian trade within the Pacific? Sorry.
Well, some of that is done directly, and some of it is also done through the facilities of Export Finance Australia. And the review of Export Finance Australia has taken place, and the broadening of their remit in recent years has been a big help to Australian business, because the tests have now changed by which EFA looks at proposals for financing. So they're an important player in this discussion, I think. But I mean, sometimes it's also not just about trade, it's also about investment. And I'd like to cite one example which I think business looked at and thought that was a really good transaction that was done between AIFFP and Airports Fiji Limited about 3 years ago, which was about a $70 million facility for Airports Fiji to do expansion of its facilities. And it was structured in such a way that there was no foreign debt involved for Fiji, because ANZ got involved, and ANZ did an instrument that made the debt in Fijian dollars. And one of the issues about a lot of these development projects is the debt that they bring to countries, which often are overloaded with debt anyway. So we thought that was a really innovative way to approach that development proposal for Fiji airports. And I think the parties that were involved seemed to gel commercially and were able to negotiate that. I think that although ANZ would probably be willing to do it in some jurisdictions, or an Australian bank, let me not verbal ANZ, but a bank would be prepared to do it in certain circumstances. Airports Fiji at that time was led by a very commercially oriented private businessman who I think drove that deal and was the reason it got over the line. But that's the sort of thing that can happen if you've got the right people doing the negotiation. You can do things through all sorts of financial instruments, and if you can reduce the amount of debt that these countries are loaded with, particularly through development loans, if you can turn them into local currency debt, that's a big plus. And I think Australian banks have the interest and the capability to do that sort of thing.
And further from that question, how do you think Australian banks help connect the Pacific to the global economy and the global financial system?
Well, the Australian banks have international connections, and so I think that's a natural evolvement of the banks. I mean, the Australian banks are headquartered in Australia. Their Australian operations look to Asia and the rest of the world, and so that creates opportunities for countries to be dragged along or brought along to that. And I think you see that a lot in Papua New Guinea, because I think PNG looks a lot to Asia for its business relationships and financial relationships. And so the Australian banks that are in PNG are in a position to actually assist PNG do that.
And just my final question. How do you think the correspondent banking arrangements provided by Australian banks support other banks and financial services providers in the Pacific?
Well, having the correspondence banking system, which is how international financial transactions work, and Australian banks, because their ratings as banks have, the top level of correspondent banking. A lot of the Pacific countries' banks don't have that same capability, and there are a number of cases where banks in Pacific countries have lost their correspondent banking arrangements, and they've found it really hard then to do international transactions. They've had to go and find all sorts of different ways to do those international transactions, which is, I don't think, in the interests of their customers or their own interests, because once you start to get outside the mainstream banks, you're never quite sure where the shadows are in that and around that anti-money laundering, counter-terrorism, financing stuff. So I think it's very important, and the Australian banks, bring first-class correspondent banking arrangements.
Senator Smith or Collins on the line? Do either of you have questions?
Good morning, Senator.
Senator Smith.
Senator Smith here, I do. Thank you very much, and good morning. Thank you for your participation. Is it true that Australian businesses in the Pacific only bank with Australian banks?
I don't know what the banking arrangements are for businesses, but I'm sure that they have a spread of banking. Big ones have a spread of banking arrangements. So I can't really answer that question.
So, assuming that Australian businesses in the Pacific do bank with non-Australian banks, and if the guarantee is limited only to banks headquartered in Australia, then it is possible that some Australian businesses will not benefit from this particular guarantee because of its restriction only to Australian headquartered banks.
Well, the legislation doesn't restrict them from transacting through local banks, and if they were transacting through local banks, it would probably be very small amounts around doing transactions associated with local engagement in projects that they might be doing. But all the Australian businesses that operate in the Pacific will have their banking services in Australia. And when they go to work in the Pacific, obviously the banks in Australia will be looking to try and keep them as a customer. So I wouldn't expect that a lot of them would bank with local banks, not on any scale anyway.
Why do you think it's necessary to restrict the eligibility to ADIs that are headquartered in Australia, rather than perhaps, for example, ADIs that might be listed on the Australian Stock Exchange?
I understand the question, Senator, but I don't think we've expressed we talk about Australian banks, but I don't think in terms of the legislation we've made a comment that it should be or should not be limited to Australian banks. But the Australian government has some limitation, I would have thought, on what guarantees it can provide for non-Australian banks. It comes down to what the government's role is in managing taxpayer funds. But it's not a part of the legislation that we have analysed closely. What we're really focused on is the importance of this legislation in creating a framework that encourages Australian banks to stay engaged in the Pacific and create some greater certainty for Australian business doing work and requiring financial services there.
What are the risks posed by the participation of Asian regional banks in the Pacific?
Can I ask a question to clarify your question? What do you mean by Asian regional banks?
Well, one of the justifications that has been made, also from commentators, one of the pieces of commentary around the necessity for this particular bill has been that it is intended to counter moves by China seeking to gain strategic footholds in the region by installing state-owned banks. So I'm keen to understand from the Business Council's perspective, what, if any, risks do you think are posed by the expansion of Asian regional banks in the Pacific?
Okay, thank you for that clarification, Senator. Look, I think Australian banks, by and large, I wouldn't expect they would bank with Asian banks because they have confidence in the banks they know, which are Australian banks. In a broader sense, you know, some of those the banking systems in other countries doesn't have the same governance around it that Australian banks have, because they're operating in the Australian system. And we think it's important that the financial systems governance in the Pacific Island countries is at a very high standard. I mean, we'd like to say the Australian standard, but sometimes these things have to be adjusted a little bit for different environments. But it comes down to, you know, breaking down the governance in the financial system because those banks from some of those countries operate out of a different governance environment.
One of the submitters to this inquiry has been the BSP, or the Bank of South Pacific, which I understand is the recipient of considerable banking services from Australians and Australian businesses. What is the justification for...
Senator Smith, can you just repeat the start of that question? It broke up a little bit.
Yeah. One of the submitters to this inquiry has been the BSP, the Bank of South Pacific. It has extensive network across Papua New Guinea, but in fact across the Pacific. How do you explain their ineligibility for this guarantee?
I don't have a view on that enables me to answer that question. We haven't discussed that as an organisation. We well know Bank South Pacific. It used to be the Commonwealth Banking Corporation in PNG, and it's certainly a significant bank there, and also across the region. And Australian companies do deal with it. And they provide extensive retail as well as business services in PNG. But I'm not in a position to comment on their eligibility or non-eligibility in relation to this bill.
Anything that would undermine an existing credible banking institution across the Pacific, if this guarantee was to consciously or unconsciously undermine the existence of an existing well-established credible banking institution, would that cause the Business Council any concern?
Can you say that again? Sorry, I missed the point.
The point is this, that having a strong and stable banking system across the Pacific is in everyone's interest. That's agreed. In the Pacific currently operates, and I would argue the case that Bank South Pacific is an example of this, credible, well-established, large network across the Pacific. If the existence of this guarantee was to undermine the operation of an already credible large banking network like BSP, is that something that would cause the Business Council some concern?
I think the Business Council would be concerned about anything that undermined the credibility of and the governance of the financial services system in any country. that it operates in. So, but we don't see evidence of that happening as a result of this bill. I can't comment on the operations of different banks. I'm really focused more on the framework that's before us.
Are you aware of any minimum service obligations that are being tied to the guarantee?
No, I'm not.
In your earlier evidence, I think you might have remarked that the CBA operated in Nauru with a guarantee. Could you just reconfirm whether I heard that correctly?
No, I'm not aware of the conditions under which the CBA is operating in Nauru.
Great. Okay.
I think I made a reference to that.
So,
that's right. So you're not aware of any conditions under which the CBA is operating in Nauru?
No, I'm not aware.
Chair, can I just,
Great.
I was going to ask a clarification on that as well, Mr. Yorn. You just might want to review the evidence that you gave, because I thought that you indicated there was a guarantee for the Commonwealth Bank. My question was, have you been informed, or are you aware, and can you give evidence that the Commonwealth Bank have or have not been given a guarantee by the government for their operations in Nauru, or is it entirely voluntary?
Any comment I made would have been based on what I've seen publicly about, or what I've heard, that there was a period of negotiation with the Commonwealth Bank to go into that market, but I don't know the details.
So there's negotiation and encouragement, but no guarantee has been announced in any way?
I'm not aware of the
right.
details.
Unlike the ANZ announcement to which you referred in your earlier evidence.
In which I've seen.
Yeah, thank you.
Yeah.
Sorry,
Thank you
Senator
very much, Chair.
Do you have any more questions, Senator Smith?
That's fine for me for the moment.
Okay. Senator O'Neill.
Just a couple of questions, if I can. Thanks for your evidence, Mr. Yorn, and for your advocacy for Australian businesses. I love your opening comments about making business possible and the important work that you do, that Australian businesses do in delivering strong, well-organised and reliable business into the area in trades, goods and services. So it's quite a big footprint that you actually have across the region, and it changes the lives of our Pacific brothers and sisters in a pretty significant way. Is it fair to say, though, Mr. Yorn, that the prudential standards edge at our sovereign borders, and that it is very different prudential standards that exist across the world no matter where you go?
Yes, they do. They vary in many jurisdictions. But one of the things I think about the Pacific, and this is an opinion, is that, they're very close to the Australian system. Central bank governors of the Pacific and Australian representatives, I don't think the governor himself may attend. They meet regularly, annually, I think, for example. There's work done by Australian institutions with central banks in the Pacific to strengthen the way in which they run their financial systems. Griffith University in Queensland has an Institute of Central Pacific Banking, which has been going for a number of years. So the banks in the Pacific are very close to the Australian systems. Some countries have better central banks than others. I'm not going to run a scorecard here, but and some don't have central banks at all in the Pacific. But by and large, the ones that do are the better financial systems, and the ones that don't, I would say.
Is it fair to say that Australia's APRA-regulated institutions, banking institutions, are highly regulated and have exemplary standards in terms of international governance?
The Australian institutions.
The Australian institutions?
Overseen by APRA.
Correct.
Yes, I would say. But, some of the Pacific banks have quite good standards too. And they have relationships with APRA or APRA-related bodies.
They do. So those relationships continue. You've also given evidence today that there's very different capabilities across the Pacific, which is a potential risk to the Australian businesses and their presence and their proper functioning and use of financial services. And you indicated that corresponding banking capacity has been removed from some of those banking entities. I think you also indicated Australian taxpayers have some views about where Australian tax dollars might go in supporting the best interests of Australians in our region. If I can go back to Senator Smith's question around support for the BSP or other entities, are they operating at the same standards as Australian banks under APRA regulation?
I don't see the detail of how they operate, so I can't comment on that. It would be unfair to comment on something that I don't really have the detail on.
Okay. You said in your submission that the provisions of this bill are a critical piece of policy infrastructure for maintaining an effective Australian financial presence in the Pacific and supporting continuing Australian business engagement in the Pacific, and to support properly functioning financial services structure in the Pacific. Do you support the bill proceeding?
Yes, that's our position.
Thank you. Thank you, Chair.
Thank you. Senators Pym or Collins, any questions? No, we're good. All right. Well, I think that's it, Mr. Yorn. Thank you for appearing as a witness today.
Thank you, Senator.
If you took any questions on notice, I don't think you did, but if you did, the committee asks that responses be provided by close of business Thursday, 14th of August.
Okay,
Thank you very much.
I know you're on tight time frame.
Thank you.
Okay, thank you for the opportunity. Appreciate it. Thank you.
Thank you. I now welcome representatives from the ANZ Bank. I understand information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Sarah Mary Stubbings, I'm the ANZ Regional Executive for the Pacific.
Martin Alistair-Joy, I'm the Group General Manager for Government Relations and Policy.
Thank you. I note that the ANZ Bank has asked that it be allowed to answer questions in camera after providing a public opening statement. The committee has considered and agreed this request. We may want to ask some questions of you prior to moving to in-camera though, but I first invite you to make a short opening statement. At the conclusion of that statement, we'll start with some questions and then suspend public hearing to take evidence in camera at an appropriate time. Over to you.
Thank you, Chair, and thank you for inviting us to appear before you today. ANZ has been in the Pacific region for more than 140 years. From our earliest days, we've financed commerce and trade to help unlock opportunities in the region for individuals, families, businesses and communities. Today we have operations in Fiji, Papua New Guinea, Samoa, Vanuatu, Tonga, the Solomon Islands, Timor-Leste, Kiribati and the Cook Islands. Our presence in the Pacific helps our customers make the most of the growing trade and investment opportunities throughout the region. We currently hold over 5 billion Australian dollars of deposits in the Pacific,
and provide over $2 billion in loans. To support our 250,000 customers in the region, we employ over 1,200 people and pay 65 million Australian dollars in wage and salary costs each year. We invest in regional infrastructure that supports economic growth and a better standard of living for the residents of the Pacific Islands. And most importantly, we work to improve the financial well-being of communities across the region. Since 2011, more than 70,000 people across the Pacific have participated in our financial education program, Money Minded. Critically, we also facilitate payments into and out of the region. This helps connect the region with global markets, supporting Pacific Island economies through trade, tourism and the movement of people. Since 2020, we've waived key international money transfer fees on payments from Australia and New Zealand to our core markets in the Pacific. We also have more than 100 account correspondent relationships across the Pacific, including where we provide clearing services for Pacific currencies and Australian and New Zealand dollar clearing services for Pacific banks. We facilitate about 25% of all payments into the Pacific and around 15% of all payments out of it. This makes us one of the largest providers of both banking and correspondent banking services across the region. ANZ's presence also helps other banks service the Pacific. While we don't provide US dollar clearing, our partner banks do, and this allows our retail and commercial customers to access our correspondent bank network and make international payments. But connecting the Pacific Islands to the world through payments and being there at all is becoming more difficult. The World Bank reported in 2024 that correspondent banking relationships in the Pacific have dropped 60% over the last decade, compared to a global average of 30%. From our perspective, there are two reasons for this. Firstly, bank returns on equity have been challenged over the last decade due to factors including higher capital requirements, more expensive technology and stronger competition. Lower returns mean that banks must make choices about how best to use their capital. The Pacific Island region is difficult because the economies are smaller and doing business in the region can be complex. ANZ is not immune to this pressure. We need to balance our desire to serve the Pacific region with our obligations to our shareholders. In 2022, for example, we made the difficult decision to exit America, Samoa and Guam. And in the last 5 years, we've closed 10 branches across the Pacific region. That leaves us with a network of 23 branches and cash centres across the Pacific. The second reason is that financial crime regulation has become more important, with tougher laws and stronger enforcement positions. Few banks, I would say no banks, have an appetite to get financial crime wrong, and we have seen higher expectations from correspondent banks across the globe. These two pressures mean that high-cost and high-risk countries that don't offer scale are less attractive for banks to serve. While the Pacific is not unique in facing this challenge, it is an area that's badly affected by it. Because of this challenge, we were pleased to announce in March an arrangement with the Australian Government in support of our commitment to Pacific banking services. The Australian Government will provide a limited $2 billion guarantee to ANZ in connection with its Pacific operations for 10 years. The guarantee covers certain eligible liabilities and is only triggered if certain trigger events occur and result in a direct loss for ANZ. The guarantee will reduce the amount of regulatory capital we hold. This adjusts an effect of Australian prudential regulation and helps address the commercial sustainability of remaining in the Pacific. Importantly, it does this without Australian Government expense, unless there is a trigger event and we are eligible to make a claim under the guarantee. In exchange, we will pay an annual fee to the Australian Government and commit to maintain minimum services in the Pacific for 10 years. These services include retail, commercial and payment operations that are important to our Pacific Island partners. This guarantee enables us to invest $50 million in technology to support our services in the region. A condition precedent to this arrangement is the commencement of the Pacific Banking Guarantee Bill 2025 or an equivalent law. The arrangements are subject to confidentiality obligations we owe to the Commonwealth. We're very happy to answer any questions on our role in the Pacific and some basic elements of the arrangement in a public hearing. However, if the committee wishes to understand more about the arrangement or the confidential details of our business in the Pacific, we respectfully request that questions about this are addressed in the private part of the hearing. We look forward to working with the committee to recommend the passage of the bill through Parliament and would welcome any questions that you have. Thank you.
Thank you. Senator Hume.
Thank you, Chair. Thank you both very much for joining us today. I just wanted to ask you first about your submission, which wasn't anything like as detailed as your opening statement, but I'm very grateful for your opening statement. You've known that this is coming up for a while. Why was your opening statement so small, considering that the alternative views, and I'm sure you've read them, particularly the one from the Bank of South Pacific, was 45 pages long.
So thank you, Senator. I suppose firstly we got the submission from the Bank of South Pacific yesterday, so that's the first time that we saw that, and we've had a chance to consider that. And secondly, as Sarah mentions, many of the details of the arrangement are confidential, so that restricts us what we can say in public about it.
But you obviously are quite happy to say an awful lot more, as the opening statement suggests. Yep. So I think that's probably took us a little bit by surprise. So can I just ask, and I don't have very many questions, but I know a lot of my colleagues do. When did ANZ first learn about the guarantee, that either the guarantee would be available or that it was something that was it something that you requested, or was it something that the government made it clear was going to be available to you?
So we've been speaking to the government for many years with both sides of politics about the challenges of being in the Pacific. The idea of a guarantee was something that we developed as a way of solving the commercial challenges that we face in the Pacific, while also allowing the Australian government to achieve its interests in the area. So, and when as was happening over the last couple of years. Okay. A range of discussions.
Okay. So was it something that ANZ proposed to government as a solution to a problem that both parties wanted solved?
Yes, that's right.
Right. Okay. And when was that proposal made specifically?
I'd have to take exactly when we put that to the government on notice, if I could, Senator.
And was part of the proposal not just the specific arrangement that you would enter in with the Commonwealth, but the supporting legislation behind it, which is this bill that's before us today? Was that ANZ's proposal as well, or was that something that the government...
I think the issue of what legislation was needed to support the arrangement is perhaps the best one for Treasury. They're the ones who understand the mechanics of government better than we do.
Right. Okay. So sorry, let me just ask the question in a slightly different way then. Was the idea of having a legislative framework around the agreement with ANZ your idea, or did that come from government?
No, we did not propose legislation.
Right. You just proposed and your proposal was specifically for the $2 billion that has been agreed?
Yes, that was developed over time, that number. Yeah.
Okay. Can I ask, in February this year, ANZ announced that it would join Bank at Post after many years of refusing to do so, and that was a sort of a missing piece of a puzzle. Was the decision to join Bank at Post connected in any way to the government offering to issue a guarantee to ANZ?
Not to my knowledge, no.
They are two entirely separate business issues.
Yeah, the guarantee was being developed over quite a few months, if not years. The Bank at Post thing was more recent. Although obviously we had an obligation in the approval that was given for the acquisition of Suncorp Bank to negotiate on the Australia Post arrangements.
Right, but there is no connection at all between these two commercial arrangements with the Commonwealth?
No, not that I'm aware of, no.
All right. I know my colleagues have more questions, but I'll turn over to the Chair.
Okay, thank you. Senator O'Neill?
Yeah, I have a couple if I can. First of all, thank you for what you do and the platform that you provide for the benefit of the Pacific region and the security for our Australian partnerships. If I can just go to different prudential standards across the area, I did ask a question along those lines of the previous witness. APRA-regulated banks, of which you're one, are obviously in conversations with other banking networks around the region, but there is some difference in governance standards that's manifested itself in a range of ways, and perhaps one of those you acted on with your withdrawal from Guam and American Samoa. Yeah, so if you could just speak to, you know, high standards but varying standards across the sector, across the region rather.
Do you want to take that one? Yeah. So every bank that operates across the Pacific has to meet the relevant regulatory standards of each country in the Pacific. So all the banks in the Pacific, so ANZ, Westpac, BSP, Bridbank, we all have to operate relative to the standards of the relevant regulator in each Pacific country we are in. So that plays out. But because we're an APRA-regulated entity, as is Westpac, we have to also then overlay any APRA regulatory requirements in terms of the amount of capital that we have to hold relative to our exposures in the Pacific. And that's probably all I can say at this point in the public forum. I'm happy to expand on that once we...
when we get into the detail,
yeah.
but it's a critical point that holding certain amounts in Australia is at a different level, a different standard from some other banks in the region, some other regulatory requirements in the region.
Well, you know, as I said, if any bank that operates in the Pacific, they have to meet the regulatory requirements of that particular Pacific country. So we all operate those pieces. We're an APRA-regulated entity, so that then dictates the amount of capital that we need to hold as an APRA-regulated entity.
Now, you're going to go in camera with us shortly to answer further questions. I think you indicated that you'd only received BSP's submission yesterday.
Yes.
Critical to the arguments that BSP advance are modelling assumptions that are embedded in the work that they commissioned from Lateral Economics. Have you had a chance to look at those modelling assumptions?
Yes, we have.
Right. Do those modelling assumptions do they hold water? Are those assumptions accurate? Can you answer that question in public?
That would be a question we prefer to address in private, if we could, Senator.
Okay. Thank you very much. Yep. Thank you, Chair.
Thank you. Senators Collins or Smith, do you have any questions before we move to in camera?
I have some questions, Chair. Yes.
Okay, over to you then.
Thank you very much, and thank you to representatives of the ANZ for being available this morning. The challenges that you identified in operating a banking service across the Pacific, are they unique to ANZ, or are they factors that would affect all banking institutions operating in the Pacific?
It's a good question. ANZ is a AA- rated bank. We can't just be a AA- rated bank in Australia. We have to be a AA- rated bank in every country we operate in the Pacific. Now, Westpac would be in a similar situation. Other banks who operate in the Pacific, local banks or who operate cross-Pacific, are not AA rated banks. So that means we have to bring the standards that we have in Australia and New Zealand to the Pacific. That creates significant complexity for us as we manage across 9 different regulatory and legal frameworks in what are relatively low scale, high risk, particularly from a financial crime and KYC environment.
So the regulatory standard that the ANZ is required to meet across the Pacific is higher for itself than for other banks operating in the Pacific perhaps by example BSB?
Again, I think that's probably more appropriate in camera. But what I would say, we are a AA rated bank. We have to operate in that way in every country that we are in. To continue to have access to global correspondent banking relationships around the world, which is critical to the Pacific region, we have to operate to that standard that is emblematic of a AA minus rated bank.
Yeah, but that is also, Senator, regulated by APRA.
Yes.
Yep. Does the commercial agreement with the Commonwealth exclude the Commonwealth making guarantees available to other banking institutions?
Yeah, unfortunately, Senator, we respectfully request we address that question in camera.
Has the ANZ calculated what competitive advantage it gets for itself over other banking institutions in the Pacific as a result of the guarantee?
So we're happy to get, again, respectfully, get into the detail of that when we're in camera. But, we don't actually believe this creates a competitive advantage for us.
The minimum service guarantees that are part of the agreement, are they set for the next 10 years, or can they be negotiated or renegotiated during the course of the 10-year contract?
So we have a 10-year arrangement with the Commonwealth, and I can disclose in public what some of those commitments are, and they will run for the duration of the 10 years. And so they include maintaining access to banking services, including face-to-face services in the jurisdictions that we're in at the moment, supporting access to international money transfers, maintaining fee-free remittances that Sarah mentioned in her opening statement, and supporting Pacific countries through infrastructure financing in line with what we do today. We're also happy to promote and grow our financial inclusion and literacy program.
Is that an exclusive list?
Again, Senator, I'm very happy to take that question in private.
Well, perhaps we might approach it this way. Perhaps you can table for the committee those minimum service guarantees that you are comfortable disclosing in their entirety, and then reserving for the in-camera hearing those other matters that are sensitive to the bank?
Yes, we're happy to set those out, the public ones, out for the committee.
Can you just provide to the committee, could you please elaborate for the committee the financial crime considerations and the cost burden that places on the ANZ?
There are multiple factors to that. There have been a number of issues in the Pacific in the past. There have been issues in Nauru, there's been issues in the Cook Islands. Vanuatu also has had a passport scheme in the past. That all goes to perceptions and challenges associated with financial crime. There are also challenges in the Pacific in terms of identity and people actually having the required identity documents. That's actually very challenging as we try and work through that. So very different to an Australia and New Zealand type of environment as we deal with those types of pieces. And then there's just the level of sophistication and monitoring that the central banks, or if they even have a financial crime team, have the ability to do. So that's also challenging. And because of what I was saying before, because we're a AA rated bank and we are very focused on financial crime, we have to take the same standards we would apply in any of our 29 countries to the Pacific. So, there's significant cost to enable us, to manage that and do that really well. And that is critical for our customers, but also the banks that deal with us and facilitate payments around the globe for Pacific Island countries. Do you want to add anything, Martin?
No.
I understand. Just a final question from myself. I understand that the ANZ sold their retail business in Papua New Guinea a few years ago to Kina Bank, K-I-N-I.
K-I-N-A, yes, that's right.
Could you just elaborate for the committee the reasons for that exit from Papua New Guinea? I noticed, I don't think you mentioned it in your opening statement.
Senator, that was sort of before my time in the Pacific, so can we perhaps...
Yeah, could we possibly take that one on notice, Senator?
Can you give to the committee perhaps a high level of understanding, or perhaps an early high level explanation, or you would prefer to provide more fulsome details on notice?
I mean, look, we spoke in the opening comments about, over time, because of the size and scale and challenges, ANZ has had to make choices about where we operate in the Pacific. And, we have obviously exited America Samoa and Guam, and we have reduced the number of branches. We have also, that decision, and as I said, was before my time, but, a decision was made to also exit retail banking in PNG, which is an environment that does have a number of local banks there that are providing retail banking services. And in fact, we sold our retail banking business to Kina Bank.
Thank you. Final question from myself. Can you give the committee an indication of what the scale of the withdrawal by ANZ or the downscaling of its presence in the Pacific might look like without the guarantee?
I think that's a hypothetical question, and we can probably possibly touch on.
No, because the guarantee has not yet been legislated. You must have an idea about what the future scenario is for the ANZ in the region, in the Pacific region, if the guarantee is not legislated. Because you would have had to present to government a scenario, a world with the guarantee in place and a world without the guarantee.
So in the absence of the guarantee, the challenges we've called out don't go away. So, as we've talked about, we have been scaling back our business. It would be likely that we would continue to consider our options around the products we provide, the services we provide, the customers that we service. That would likely continue over the course, of our ongoing time in the Pacific.
Okay, thank you very much. Thank you. Thank you, Chair.
Thank you, Senator Smith. I understand Senator Collins has dropped off the call. Is that right?
I am here.
Oh, you are there. Sorry.
That's okay.
Okay. Any other questions or comments from anyone before we move to in-camera?
I would like to ask some questions, but I'm happy to ask it in camera as well, but we can give it a chance to see if it works here first.
Okay.
I've got one clarifying one.
All right, maybe we'll...
camera.
Yeah, so Senator O'Neill, some clarification. Perhaps if you're easy either way, Senator Collins, perhaps we'll move to in-camera so we don't kind of duplicate, if that's okay. Yep.
So I just want to clarify evidence that you put on the record today and to make sure I heard you correctly. So what is proposed is a limited $2 billion guarantee for 10 years, and then you identified for Senator Smith 5 criteria that were fundamental to that agreement. I think, Dr. Joy, you indicated that the $2 billion was arrived at after a period of consideration of what would be appropriate. I think, Ms Stubbings, you referred to certain liabilities and reducing the capital we hold. And you also indicated that the $2 billion guarantee would not be required unless there was a triggering event. Is that all correct? And could you explain how your retail communication and payment systems, if the guarantee goes ahead, will be enhanced? Because I think you mentioned $50 million. I wanted to get the status of what that $50 million investment looks like at the moment.
Sure.
Yeah, so in terms of what you've recounted, in terms of our testimony, we confirm that's correct.
Okay.
In terms of the $50 million, we can talk about that.
Yeah, so the $50 million is to be invested in our sort of retail and commercial banking systems. It's basically a core system.
Is that future?
Yes, so it's basically a core system replacement and also upgrading our digital tools. So it's a significant investment for us in the Pacific.
And is that contingent upon the passage of this legislation to provide the guarantee?
Yes.
Okay. That's very helpful. Thank you very much.
Okay, so the committee has agreed, and we now, I think we'll move to in-camera to ask some additional questions. So the committee will now suspend the public hearing and resume at 1 p.m. So I think now those online and join the other line that's been provided to you, and I Garrott and Ms. Kulu from BSP Financial Group. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
My name is Nuni Kulu. I'm the Group Chief Operations Officer for BSP Financial Group Limited.
And Glenn Scarrett, Group Financial Controller for BSP.
Thank you for coming. I now invite you to make an open... Oh, now, you have circulated a statement, haven't you? So I don't know if you want to make a short opening statement in addition to what you've tabled, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Okay. Thank you, Chair. I am Nuni Kulu, Group Chief Operations Officer for the BSP Financial Group Limited, and I am joined today by my colleague Glenn Scarrett, BSP's Group Chief Financial Officer. So warm greetings from PNG. Our Chief Executive Officer, Mark Robinson, extends his apologies for not being able to join us in this hearing, as he is currently in Bougainville for a long-planned visit, meeting government officials, customers and our staff across the 4 branches in Bougainville. We appreciate the opportunity to make a submission and to appear before the committee. Senator, BSP is the largest financial institution in the South Pacific and headquartered in Papua New Guinea. It does operate across the 6 other countries, Fiji, Solomon Islands, Samoa, Tonga, Cook Islands and Vanuatu. We serve around 2 million customers, employ over 4,600 staff, and provide the full range of retail, business and digital banking products. Our footprint comprises more than 120 branches. Many are located in very rural and remote communities across the region, and complemented by the region's most extensive digital banking network. BSP was founded in 1916, shaped by a century of partnership between Australia and South Pacific. We are dual listed on both the Australian and PNG exchange, and we have long-standing operational links with major Australian banks as well as Australian investors. Importantly, BSP remains overwhelmingly South Pacific owned. 97% of shares are held locally through PNG government, super funds across the region, landowner groups and even churches, and broadening our impact across millions of households in the South Pacific. Our engagement is crucial for regional prosperity, financial inclusion and stability, with nearly half the region's deposits and lending and the largest loan books in all but one core market. Our regional contributions are significant. Over the past 5 years, we have paid over about $1 billion Australian in corporate taxes, comprising 17% of PNG's non-resource corporate tax revenue in 2024, and we have distributed 1.5 billion Australian dollars in dividends to our regional investors. In addition, BSP is a substantial investor in local government bonds, supporting sovereign debt and national development. And we're currently undertaking a 250 million Australian dollar program to upgrade digital channels, our operational resilience, advancing financial inclusion and connectivity, and without government support. Our extensive regional presence, with particular emphasis on the underserved rural areas, means BSP is vital to daily economic life and community services. Any measures that distort the market or affects our resources could have direct consequences for maintaining regional services, ensuring accessible and secure banking, and driving the digital transformation that the South Pacific urgently needs. Policies or guarantee regimes that exclude locally headquartered banks undermine competition, innovation, and our capacity to deliver and expand essential banking services. Senator, the inclusion of regional banks in future policy design and consultation is critical for the stability, resilience and prosperity of our South Pacific communities. And I would now like to invite Glenn to talk to the specific details, impacts of the current bill.
Yeah, thank you, Nuni, and thank you, Chair, for this opportunity. Building on Nuni's remarks, I'll focus on the specific financial and strategic impacts of the Australian Government's Pacific Banking Guarantee. We recognise and support the Government's intent behind the guarantee, especially in the context of the withdrawal of Australian banks from the Pacific. However, we believe as currently designed, the bill and announced guarantee presents significant risks for BSP and our stakeholders. The guarantee is limited to Australian headquartered banks. What we believe it does is potentially lower the capital requirements and funding costs while excluding regionally headquartered firms like BSP. According to the analysis by Lateral Economics, which we have included in our submission, this could cost BSP between 9 and over 15 percentage points of our market share under varying scenarios, a loss of which equates to tens of millions of dollars in annual net earnings. This reduction would likely inhibit our ability to finance small businesses, invest in technological upgrades and support public services, the very outcomes this guarantee aims to support. Furthermore, excluding local banks from such a regime risks crowding out regional players, potentially impacting government borrowing costs and employment and undermining the growth of local credit markets, as noted by international bodies including the OECD. The guarantee's current structure, featuring open-ended appropriations, unclear pricing criteria and confidential arrangements, creates further uncertainty around its market impact. In light of this, we recommend the government broaden eligibility to include significant Pacific headquartered banks with substantive Australian links. We suggest the inclusion of Pacific headquartered banks only as a means to mitigate some of the potential impacts on BSP that I've outlined earlier, including market distortions. We also recommend ongoing transparent consultation with regional banks regarding any future guarantee arrangements. We value our partnership with governments, and beyond this current discussion on the Pacific Guarantee Bill, we look forward to fostering a strong relationship with the Australian Government to ensure a sustainable, inclusive development across the South Pacific. We welcome the committee's questions.
Thank you both. I will hand over to Senator Hume. Thank you. I've only got a few questions, but I know my colleagues have some, so I will make some space for them on the agenda. You mentioned broadening eligibility. I don't have a good sense of who else in your market would be eligible should your definition of, or your reframing of what headquarters in Australia means, or that eligibility criteria. How many banks would that open this scheme up to?
Yeah, thanks, Senator. There is one other bank in Papua New Guinea similar to BSP. It's Kina Bank. Kina Bank is similar to us, and that is listed on both the PNX and ASX.
Right.
Kina Bank was the bank that purchased the
yes,
branches.
the retail branches, yes. Can I ask, your market share is, you're the dominant player in the region, are you not?
Correct, Senator.
Yeah, okay. And what is ANZ's market share and other players, Kina Bank's, for instance, market share?
It differs for different markets.
Yes.
But certainly in PNG, the largest market, our market share would be around 65%.
Right.
ANZ's market share would be probably close to 30%. Mm-hmm. Taking that into account, we service all markets in PNG, from the man on the street to the small, medium enterprises to the corporates and governments. Mm-hmm. ANZ largely concentrates in the corporate market.
Mm. And I suppose something I'm not particularly clear of is the regulatory environment in which you operate. Is it a similar or mutually recognised, if you like, regulatory market in each of the Pacific nations in which you operate, or is there a different regulatory market for each? And certainly I'm assuming that APRA, our regulator, is not necessarily one of those markets, one of those regulatory frameworks.
Thanks, Senator. Yes, I can confirm that each location has its own regulator. Each country has its own regulator. Mm-hmm. I would. APRA is not. We're not regulated by APRA. I would say that the regulatory frameworks in many of the South Pacific nations tend to be little less stringent mm-hmm. and less resource intensive mm-hmm. than what we have here in Australia. But that's not the same as those regulators being careless or lax. No. It's more about the capacity and the maturity of the regulatory environment or the nation. Australia's regulators are large, well-funded bodies the regulatory frameworks across the Pacific are proportionate to the size and complexity of their particular markets. And they are continuing to evolve towards global best practice. What I would say in relation to BSP, however, we apply the highest standards, and we would be happy to put ourselves in any of the most rigorous of jurisdictions when it comes to our regulatory compliance.
Is there a particular market, and I'm not talking geographic, I'm talking product segment, that you are most concerned about losing market share or customers to ANZ or to other Australian banks because of this bill? Is it one type of product? Is it deposits? Is it correspondent banking? What is it?
That's a good question. And it's very hard for us to answer that because there's a lot of that's behind confidential arrangements that we're not sure of, but there has to be incentives for ANZ to stay. And what we're concerned about is their ability to reprice in the corporate segment. The corporate segment is the most profitable.
Right.
It's the area where we make enough profit in that space. It allows us to invest into our 122 branches across all provinces in Papua New Guinea and islands that we operate. So it's that core segment, the corporate segment that we're concerned about.
If you could be assured that you, even with this arrangement, that you still remained on an even playing field in that particular segment, would that satisfy BSP?
If we can be assured that there is no impact commercially to us, that we would be more than happy, yes.
Can I ask the extent of consultation that BSP had with the Australian Government or with Treasury during the development of this bill?
Senator, we weren't consulted during the establishment of the bill. Saying that, BSP, I would like to say BSP hasn't done a great job at introducing ourselves to the government or to Treasury. We've been working on that in the last couple of months.
Fair enough. How could future guarantee programs then be better designed to better include other banks that provide critical services other than extending the definition of headquartered in Australia?
Well, I think the first thing that we would recommend is more visibility over getting an understanding of the impacts on whether it be a guarantee or whatever the incentive is. Consultation, I think, is important. Prosperity across the Pacific is something that we're entwined with. We think that we've got a lot to offer in terms of consulting and coming up with plans to make the Pacific more prosperous, and we welcome supporting the Australian Government on that.
Yeah, I mean, I think we all have exactly the same goal in mind at the end of the day. I suppose, what's the counterfactual? If Australian banks started removing their business from the Pacific, what would be the implications for your business?
If the Australian banks were starting to remove, we would likely try and take up the slack. To be completely fair.
Would other international players also try to take up that slack?
It's a hard place to do business, and I think which is why a lot of the Australian banks are leaving. So it would be difficult for players to come in. We've got fantastic relationships with our correspondent banks. We've got 4 correspondent banks. We're very secure in those relationships. So we think we would do okay. I think it would be hard to attract new players to the market.
What other international competitors do you have in the markets in which you play other than Australian banks?
There is French banks across the region. Bread Bank is in a number of jurisdictions. There are a number of other locally owned Papua New Guinean banks. There's actually been 4 new banks established in PNG, local banks established in PNG in the last year.
And what about in that government and corporate sector, as opposed to retail banking provision?
Obviously, Westpac covers Fiji and PNG, ANZ and BSP would be the three banks that largely cover those markets.
All right. That's all I had. Thank you, Chair.
Thank you. Senator O'Neill.
Thank you very much, Chair. Could you explain how to the committee how BSP is currently affected by Australian regulatory capital requirements that are the target of this bill?
Thanks, Senator. We're not impacted. We're not regulated by APRA, so there is no regulatory capital requirements set for us by an Australian regulator.
Okay. So you sit outside our regulatory capture and observation.
We sit outside APRA's. Being ASX listed, we do have certain regulatory rules to follow, market listing rules, etc. Being ASX listed.
But you wouldn't not equate that with the level of scrutiny that the banks have to be subjected to comply with their licensing here under APRA?
We're regulated by the Bank of Papua New Guinea, which mirrors a lot of its regulations on APRA. So we're not regulated by Australia, we're regulated by the individual regulator in each country that we operate.
Yeah, because the sovereign, those sovereign entities have responsibilities to their sovereign peoples.
Correct.
Okay. Can I just ask, ANZ indicated they were A minus, I think, in terms of their status. What is the status of your bank?
We actually don't have a rating. We've had no need to be rated at this point.
Okay. Does that provide you a commercial advantage?
Not being rated?
Yeah.
No.
Okay.
No.
So why would you not be rated if there was a commercial advantage in being rated? Because ANZ made a very strong point about how critical that was and how that underpinned the standards that they operate at outside of their obligations to APRA.
Yeah, Senator, we've had no reason to. Our funding comes from our deposits, so we don't go out to market and source funding, which is largely where you need a rating.
Mm-hmm.
So the fact that all of our deposits, all of our lending is based on the deposits that we hold means that we don't really need to have a debt rating.
Okay, thank you. So we've clarified that your organisation doesn't operate under the Australian regulatory framework and that it is the frameworks that are set by PNG that you apply.
For our PNG bank.
And then for the other governments, you apply their standards.
Correct.
Which vary across the Pacific.
They do.
In the level of complexity or sophistication or compliance with, anti-money laundering, counter-terrorism finance.
They are all very similar, and they follow APRA very, very closely, but they do differ to some degree.
Could I just ask if your organisation pays tax in Australia?
No, Senator, we're not an Australian tax resident.
Okay. Where do you...
We don't pay tax. We do obviously have a large number of suppliers based in our opening statement we talked about. We've currently got a $250 million Aussie dollar improvement program underway. A lot of that is actually being sourced from Australian suppliers.
Okay, thank you. But you primarily pay tax in which jurisdiction?
Papua New Guinea, where we're headquartered.
Okay. I guess asking for the Australian taxpayers, who certainly have a connection to our Pacific brothers and sisters and a very, very strong connection to PNG, there's still the question of, value for money. And I want to ask for your view. Given that you don't pay any tax in Australia and you're not regulated by an Australian entity to that same standard that we know, why should the Australian government provide a guarantee to such an organisation as yours that aren't subject to that Australian regulatory framework and don't pay tax in Australia?
Yeah, thanks, Senator. We come here today not necessarily looking for a handout from the Australian government. What we came here looking for is a level playing field. We share the Australian government's intentions in the Pacific. we feel that the guarantee that they're offering will have a negative impact on us, which means that we think that the actual impact on the Pacific may not be as the guarantee intends. So what we've tried to do is, how do we mitigate the impact of that guarantee? And we thought, well, if we shared the guarantee, then potentially that's a way of mitigating it.
Okay, so that's your request and that's your rationale for doing that. I guess one of the things you've spoken about with Senator Hume was consultation. Can I put it to you that the modelling assumptions and the scenario definitions that underpin the entire reason that you're here with us today, which is a fear of unfair competition, are not based on a deep knowledge of what's been negotiated, because that is still commercial in confidence. Is that fair to say?
That's absolutely correct.
Right. So these scenarios that you have in the lateral economics modelling assumptions and scenario definitions at 3.3.2 are not the subject, didn't arise as the subject of consultation with anybody who knows about what the guarantee is. This is just your anticipation with some anxiety about competition that's led to these particular scenarios being modelled.
Yeah, unfortunately, we've not been involved. And the commercial confidence, we haven't been able to establish it. So to your point, we've looked at how would it potentially compete, how would they, and we came up with those various assumptions.
Okay, and you've been sitting in on the hearings this morning. Have you heard any of the evidence?
No, Senator.
Oh, okay. So there was some evidence from the ANZ Bank, which was on the public record, but also some in private, that may be of considerable interest to you. Could I just ask you a question with regard to the modelling again in the submission? Does your modelling, if I look at this carefully, does it assume that the guarantee will cover loans made by Australian banks in the Pacific? Is that a fair summation?
Lending to clients?
Will it cover loans?
If your definition of loans is ANZ providing lending to clients, yes, it does.
Okay, so that may or may not be the case. You don't know.
That's right, we don't know.
Because that information is locked away from your visibility. Okay, so now I understand a lot better about why you're here, and the information sharing might not be complete. If your fears are not realised, if this is not how it operates, there's no problem here, really, is there?
As long as there's no commercial advantage to ANZ that impacts our ability to compete fairly, we'd have no concerns.
Yeah, and your main concern is about these covering half the corporate existing lending, Westpac taking up the same sort of model. It's all about lending.
Yeah, where we compete with ANZ is largely in lending in the corporate sector.
Mm-hmm. Yeah, okay. I think that there's a big part of the problem for you. You're flying blind. And we can't reveal things that are revealed to us as commercial in confidence. Treasury will be up shortly and we can ask them some things in public, but I'm sure that you would be very interested to read the testimony of the ANZ Bank from this morning, which put quite a bit on the record about the guarantee, what they've negotiated. They put quite a bit on the public record. So you please take the opportunity to have a look at that. I won't verbal what they said. I'll leave that to you to give consideration to. Thank you, Chair.
Thank you. Senator Smith has some questions, I believe.
Thank you very much. Thank you to witnesses from the BSP for your appearance today. Has the BSP sought to negotiate its own guarantee with the Australian government?
Thank you, Senator. No, we have not.
Is that a objective, or is that a plan that the BSP might pursue?
Senator, it's not something that we've considered at this time.
would it be a suitable outcome? So if the BSP was required to operate across the Pacific under the same regulatory standards as the ANZ Bank, what would that mean for your business?
Senator, that's a difficult question to answer without having a real understanding of what those differences are. As I mentioned earlier, BSP's regulatory regime is held to the highest level of standards. We currently are regulated by the 7 independent regulators which we operate. There would be requirements for us to potentially do a little bit more in terms of regulation, but it is largely what we're already doing what we are at present.
So the differential, if I could use that word, the differential between the regulatory standards required by the ANZ to operate across the Pacific are different to those that are required by the BSP. So that differential, doesn't that give the BSP a commercial advantage?
Senator, I would argue that it doesn't give us commercial advantage. Our regulatory regime is pretty extensive. I would say that. Sorry. Back to your question. I don't think that it would give anyone an advantage.
Right. Have you sought to engage with the Australian government to better understand, engage with the Australian government or with ANZ to better understand what is the true nature of the commercial arrangements?
Senator, we haven't met with ANZ. We have met with Treasury a few weeks ago, and we also made a trip to Canberra a few weeks ago to introduce BSP. But at this stage, all of those arrangements are under commercial confidence, so we're not aware of them.
Right. Just to follow on from Senator O'Neill's point, the lateral economics report, how has that developed in the absence of knowing what is the exact nature of the commercial agreement between the Australian government and ANZ?
Yeah, thanks, Senator. It's probably one for Lateral, whose report owns, but I could certainly say that they would have looked at where does the ANZ and any other potential guarantee holder compete against BSP, and how potentially a guarantee might impact those that competition.
Right. So it makes bold and courageous assumptions.
Sorry, Senator, it does make assumptions. Yes, the fact that we don't know what the guarantee is required assumptions to be made.
Okay, and of course, and up until this point, you're still not able to verify or do any assessment of whether those assumptions are close to the mark or off the mark.
That's correct, Senator.
Okay, thank you very much. Thank you, Chair.
Thank you. Does any other senator have a question? No. Senator Collins? I think...
No, not for me. Thank you so much.
Senator Colbeck.
Thanks. Thanks, everybody. Just in relation to, I mean, you're making assumptions as part of the process, but what would be the benefit to BSP of such a guarantee based on your current assumptions?
Sorry, Senator, I didn't hear that last word.
What would you say benefits to BSP of a guarantee of the like that ANZ has based on your assumptions?
Well, our understanding, the assumptions were based on ANZ not requiring as much capital for their Pacific operations. By not requiring as much capital, effectively means that their funding costs would not be as high, and therefore they could price their loan products differently. So a way for us to do something similar would be have some sort of guarantee which effectively enables us to again take advantage of the fact that you're guaranteed by a AAA government, which would allow you to effectively price it differently.
But the ANZ talked about them relying on their AA- rating. You don't have a rating, and because you say because all of your lending is based on deposits. So how does that work its way through the system? I mean, there's an advantage to the rating or there's not.
That's correct. We aren't rated. We would need to, I guess, understand the guarantee better, Senator, so that we could look at a way that we could mirror the impact that we think that it may have.
So in terms of your
is a level playing field.
Yeah, I understand. I understand. I think we all do understand where you're coming from, and the fact that you don't know that some of the information makes your position difficult in some sense, or it makes your position difficult. Does the fact that your lending is based on your deposits limit your capacity?
In some countries, Senator, we are coming up against our internal limit. In Papua New Guinea, our current rate is about 70% of what our deposits we've lent out. So there is plenty of headroom still in that space.
So it's jurisdiction in each of the jurisdictions that you cover.
That's right. So currently, the deposits we raise in each jurisdiction are what we lend in that jurisdiction.
Okay, and that's based on the regulations of those various jurisdictions.
No, we could source other funding. That's a BSP policy at this stage.
Okay. Part of the evidence with the difference in remittance costs in various jurisdictions, what are the drivers of those things? Are they by country requirements?
Senator, it does differ. I could only sort of talk to BSP and where we are in the remittance space. We're not based in Australia or New Zealand or the US, so we don't do any remittances. But what we do is largely at the end of the day, the individual receiving that remittance needs cash. So BSP has the largest branch network and controls the cash in the majority of these locations. So if a Western Union or another bank sends remittances to the location, it'll be our branch that the individual goes to pick up that particular cash from, and we provide that service.
And so each jurisdictional requirements would impact on the cost in that jurisdiction.
That's probably a question for the remitter, because I'm unsure of those remittance fees based on the fact that we don't actually do any of those remittances.
Okay. Are there any other players in the market that have government-backed guarantees?
Senator, not that we're aware of.
Are there any particular players that have more dramatic market growth at the moment than others?
No, Senator, the Pacific, they all are slightly different. They all have different markets. Fiji, heavily tourism-based, PNG, resource-based. So that each one is an individual, but at this stage I wouldn't say any of them are overly different to one another in terms of the size of that growth.
You said in your submission that in Pacific markets, Australian banks are lending at highly competitive rates compared to local banks. What's the margin there?
Senator, it depends on again in the jurisdiction. If we speak to if we speak to Fiji, the Australian banks would probably have I think it's probably about 100 basis point margin on us currently in the corporate space.
That's your largest market?
Papua New Guinea is our largest market.
Is that sort of common across the others? That's the sort of difference that we have?
Within the corporate segment, that's probably about right, yes.
I think we'll do me. Thanks, Chair.
Thank you, Senator Colbeck. Are there any other senators online who have a question? I'll take that as a no. Senator Hume? No. Okay, well, I think that's it from us. Thank you for appearing as witnesses today. We appreciate it. If you took any questions on notice, the committee asks that responses be received by close of business Thursday, 14th of August. And I think that is all. We can let you go now. Thank you very much.
Thank you.
I would now like to welcome officials from the Department of Treasury and the Department of Foreign Affairs and Trade. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today, in any direction?
Andrew Cumston, Assistant Secretary for Economics and Trade in the Office of the Pacific for the Department of Foreign Affairs and Trade.
Tim Baird, Assistant Secretary at Treasury. I run the Banking Credit Currency Branch.
Amelia Claringbold. I'm an Acting Senior Advisor in the De-Risking and Resilience Unit at the Department of Treasury.
I'm Portia Herbert-Funk. I'm the Acting Director of the De-Risking and Resilience Unit at the Department of Treasury.
Thank you. I note that Treasury has advised the committee that it may wish to answer some questions at today's hearing in camera. The committee has considered and agreed this request, and if required, the committee is able to move to an in-camera session at today's hearing. But first, before we do that, if you have a short opening statement, we'll hear it now, and then we can invite members of the committee to ask questions, and then we'll move to in-camera when it seems right to do so. Over to you.
Thank you, Chair. So I don't have an opening statement, but just a point of clarification in terms of what we're able to cover in the public forum and where we might need to move to an in-camera session. So we're happy to talk generally about the commitments that ANZ has made in exchange for the guarantee, the reason for the special appropriation and the legislation, Australia's interest in Pacific banking, the expected impact on competition, and the rationale for the guarantee, as in a similar position to ANZ on details of the guarantee arrangement itself, in terms of the risk profile, the liabilities that are covered. Would respectively request to answer those questions in camera.
Can I ask a question then? You've identified, was that 4 or 5 categories that you can answer questions on?
Yes.
Why don't you just give us some information on that to start with?
Yeah. Okay.
Because
so I might ask Mr. Compton just to talk in terms of the background to why the government is looking to support the Pacific in banking.
Thank you, Tim. So the phenomenon of fragile and smaller markets gradually losing their banking connections is worldwide, but is most acutely felt in the Pacific. If you look at the statistics of correspondent banking relationships to the Pacific over the last 10 to 15 years, they've been in quite serious decline. And this has, in its most extreme example, been in the cases of at least 2 countries in the Pacific coming very close to losing all banking links. So this has been something the region has been very concerned with. They have raised it both with us bilaterally and multiple times in the Pacific Island Forum. So Australia has been listening. And we recognise the crucial nature of these banking links, particularly with high quality, well-regulated, respected Australian banks. They're essential for not just financial connectivity, but also for trade, for remittance flows, and for basic social services. And Australian banks have been, as ANZ testified, have been in the region for 140 years and have been an essential backbone of the Pacific, of Pacific life, and essential backbone of linking Australia to the region. So we, with our Treasury colleagues, have been working very hard to maintain this connection because, as ANZ has already spoken and has spoken about publicly multiple times, including at last year's Pacific Banking Forum, and actually as BSP also testified, it is a hard region to do business in. The markets are small, the regulatory complexity is high, and the return on capital is lower than in Australia. So we have been working in collaboration to try and address some of those challenges.
Move on to the next item, unless the committee has questions on that. So in terms of the commitments that the Commonwealth has secured from ANZ, so we've secured a 10-year commitment across all of the markets that ANZ is currently operating in the Pacific to maintain face-to-face banking services, including digital services, supporting their ongoing access to correspondent banking, which, as Mr. Cumpston has indicated, is a high priority for Pacific Island countries. a $50 million investment in digital banking and continuing their work on promoting financial inclusion and literacy, as well as looking to support countries with their infrastructure financing programs as well. In terms of the special appropriation and the reason for the legislation, so the special appropriation is required essentially because in the unlikely event that a payment is required to be made under the guarantee, that could happen outside of the annual appropriation cycle, and in circumstances such as these, it is typical for a special appropriation to be put in place. And then finally, maybe I'll address the competition element, and then see if the committee has questions. So the guarantee has been carefully designed to be non-distortionary and is not expected to impact competition in Pacific Island banking markets. The purpose of the guarantee is to, and I think ANZ's covered this in their evidence, is to release regulatory capital in Australia. Pacific banks are not required to hold regulatory capital in Australia for their Pacific operations. The guarantee, in effect, places ANZ on the same level footing as banks operating in the Pacific today. Yeah, I'll leave it there. So I'm happy to answer the committee's questions.
Thank you very much, Mr. Baird, and thank you to all of you for attending. I want to confirm that the bill itself creates an ongoing and uncapped appropriation.
That's correct, Senator.
And what is the thinking behind that? That would be very unusual, and I want to know why it's necessary.
So, as it stands today, there is only one transaction, which is the $2 billion transaction with ANZ. There are other Australian banks that operate in the Pacific, and the appropriation bill would create flexibility to enter into agreements in the future with ANZ or other banks.
I should ask, is there anybody in the region that's bigger than ANZ of the Australian banks?
No, Westpac only operates in two markets, Fiji and PNG. And then Commonwealth Bank is just about to enter into Nauru. So they're the three banks that would be sort of Australian banks that operate in the Pacific currently.
So assuming that ANZ is the biggest operator that's existing now, and they've got a $2 billion guarantee that's going to last for 10 years, and that's public knowledge, why would we need to have an uncapped appropriation? Why would we not say, all right, let's give us the wriggle room to have, up to 10 billion or 5 billion or whatever it might be? But this idea of an uncapped appropriation essentially means, and perhaps you can confirm this for me, that any future government could say, yeah, we're going to do a $100 billion guarantee next time around. Is there anything stopping a Commonwealth entering an agreement for a $100 billion guarantee in this legislation?
So no, Senator. I guess maybe to come back to the first part of your question, we understand that it is quite common for special appropriations to be uncapped, and we did have a look at the Department of Finance data. There's currently 240 special appropriations authorised by legislation, and 173 of those are unlimited in nature. So this isn't out of the ordinary in that sense. If the government chose to put a number out there, one of the disadvantages of an approach of providing a specific number is it could anchor future negotiations with banks if there is a number out there. So that would be another reason not to say that there's to use the number you provided, Senator, a $10 billion number, then that could anchor future negotiations with banks.
I mean, I think one of the premises of this legislation is that its intent is welcome from both sides of the chamber, whether it be government or opposition. The two parties of government are in favour of doing this. However, I think there is a natural hesitation at giving any future government, whatever hue they might be, an uncapped appropriation, which does seem to be a little bit of overkill. So was that a specific request of the Minister? Was it a suggestion of the Department? Why do we need to have this as an uncapped appropriation?
My understanding, and I might ask Ms Claringbold if she has further information on this, is, as I said previously, Senator, that this is fairly standard for special appropriations, but I might just ask Ms Claringbold if there's any further information in terms of the...
And Ms Claringbold, I suppose the reason that I ask is that if you've got two parties of government that agree that this is a good idea and that would like to be able to ensure that there is an Australian presence in the Pacific in the financial services sector, if there was a specific reason why you needed more than whatever was assigned through the appropriation, I'm certain that it would be something that could be expedited and negotiated between the two parties of government. Yet this does seem to be an unnecessary guardrail that has been lifted.
And maybe just, so Senator, I think, yes, part of the rationale is clearly to provide flexibility for future arrangements with banks, but in terms of any further background, is there anything to add?
I think, yeah, just probably echo your point, Mr. Baird, that there's a number of special appropriations that do not have caps on them.
What are these? What are some examples?
I don't have the list to hand, but there is the Department of Finance does publish a chart of special appropriations, and as Mr. Baird has said, as of 1 July 2025, there are 173 which are unlimited.
Any of them
in
this
nature.
kind of size?
We're happy to take that on notice, Senator. We don't have any sort of further information to hand other than that statistic that we've just provided you.
Okay.
If I may as well, while the special appropriation is not proposed to have a direct dollar limit, there is obviously a maximum amount on the guarantees, and the Commonwealth would not provide an unlimited guarantee.
Can I ask a clarifying question about what you described as a disadvantage of having it capped? And could you sort of play out the scenario for the point at which that would hamper negotiations?
So if the government was to approach one of the other Australian banks and offer a guarantee, and they're aware that there's currently a $2 billion guarantee with ANZ, but let's say, for argument's sake, a $10 billion cap, then they would recognise that there's $8 billion available. Yeah.
And then that becomes part of the negotiation. Right, so this is, if we were a business, it would be not exposing our hand and putting ourselves at risk, and that's what the government's doing. It's a conservative position to prevent gaming by a potential partner in the future. Okay, all right, that's clear for me, thank you.
I suppose, except that knowing that ANZ is the biggest player in the area, who else is going to come in that's going to demand more?
Yeah.
So it does seem like a little bit of overkill. I wonder, can I ask, the term, the value and the beneficiary clearly are not commercial in confidence. Is that part of, is that always going to be the case? Is there rules around in the bill around what parts of a negotiation can be commercial in confidence and which ones must be made public?
I don't believe that that's covered in the legislation, Senator, but I would expect that a similar approach would be adopted for future guarantees, that the terms and the amount would be publicly available.
Right, but that's not specified in the legislation. So could there be a situation where we say, right, another deal has been done, but we won't say who it's with, and we won't say for how much it is, and we won't say for how long it is for?
I guess it's a hypothetical question, Senator, and yeah.
It is, but if the legislation allows for that, does the legislation allow for that as far as you can see?
I don't think there's anything in the legislation on what needs to be disclosed in relation to each transaction.
It did occur to us during the in-camera session, and I've got to be very careful about what I say here, is that there are some elements of the agreement that are commercial in confidence which potentially don't necessarily need to be. And because of that, if those elements weren't necessarily commercial in confidence, it might allay the concerns of some of the other players in this industry. is there a reason why there are some elements that are commercial in confidence and yet not others? When ANZ were asked about this, they said that really is a matter for the department.
Yeah, and look, so there's a number of reasons. Some we can cover now, some we might need to cover in camera, but primarily it does hamper the government's ability in terms of future negotiations if information such as fees, liabilities were in the public domain. That is very commercially sensitive information for any future, not just in relation to this specific piece of legislation, but any government negotiations with other parties on guarantees, for example.
Can I ask if any other solutions, alternatives were considered to address the objective of these bills?
Yes, Senator. Look, we, as you would expect, considered a broad range of options, including, things like direct subsidies, for example. This arrangement, in sort of our advice on this arrangement, is that this was the least cost, least risk way to achieve the objective, rather than providing direct funding or, for the Australian government to look to provide the services themselves, for example. There are a whole gamut of options that you could consider, but our view was that this was the least cost, least risk way of addressing the issue.
I want to ask you about the risk side of things, because obviously the EM provides that the risk of the Commonwealth needing to make a payment is very low. What does very low mean? Has very low got some sort of numerical threshold or a metric of some sort?
And Senator, that's probably getting into we're very happy to provide you that information. We have the modelling and we can talk through that in a lot of detail, but we're not comfortable covering that in this.
That's fine, but it's in the EM of the bill. Yeah. So I would understand why you might want to keep that issue, commercial in confidence, for the specific deal. But is there something that is publicly available on what is very low, if it's in the bill? Very low risk.
So I might ask Ms. Claringbold, there are mechanisms in the frameworks that the Department of Finance operates around percentage thresholds.
Yeah, I haven't. I'm not aware of what the threshold might be for very low risk assessment.
Is very low a specific risk assessment, or is very low a phrase?
Or what the number? Yeah, what that number means. Yeah.
And I suppose one of the things we want to understand is who makes that assessment. Do you get advice from, I don't know, what about the Australian Office of Financial Management or somebody like that specialises in this area of risk assessment?
What's the trigger and who's the arbiter? Yeah. So on the risk assessment, we did receive commercial advice on that, and also consulted with internal stakeholders, including working with the Department of Finance as well. So classifying them as an internal stakeholder. We also spoke with ANZ on their historical experiences around the particular eligible liabilities that we are guaranteeing, and looked at, the commercial advisor looked at kind of historical data as well to inform their assessment.
Is one of the alternatives that was considered here a request to provide or to embed an excess agreement in a guarantee like this? Is that appropriate? Is that something that features in other similar agreements?
Senator, are you able to elaborate a little bit more?
Okay, so I crashed my car, and if I crash my car, I have to pay the first $600.
Yeah, and Senator, we'd be happy to answer that question in camera in terms of the arrangements. Yeah,
I think we can say, though, Senator, that there is a risk share arrangement. Right. So the Commonwealth doesn't bear the full risk of the guarantee.
But that's just for this particular deal. It doesn't necessarily mean require every negotiation under this bill to have those same features. Is that right? Each agreement can have different features. Right. Okay. All right. I might have some more questions, but I'll move on to other colleagues.
We might move in camera, I think.
Can I ask just one on the record? This morning, I think it was inadvertently stated, and there may be a correction to the record, that there is a guarantee in place with the Commonwealth Bank for its replacement of Bendigo Bank on Nauru. Can you clarify the exact position that actually exists?
Yes, I can confirm that there is no guarantee in place between the Commonwealth and the Commonwealth Bank.
So can you also guarantee that there is no plans to on that particular arrangement?
I wouldn't want to sort of speculate on future government decisions, but I could say there's no discussions. There's no discussions in relation to that currently.
I think it's public knowledge as well that the Commonwealth Bank of Australia has received no government support for its operation in Nauru.
Sorry, I'm interrupting you, Mr. Senator O'Neill, but can I just be very clear that at the time that that deal was, or that arrangement was put into place, this bill didn't exist, or the prospect of this bill didn't exist. Do you think that the prospect of this bill existing now opens up the floodgates, if you like, to new arrangements being made or being sought?
The short answer is no, Senator, and again I can elaborate in camera. Yep.
Thank you.
One more if I can, Chair.
Yes.
Our last witnesses, BSB, indicated that they had no objection to the bill if it did not prove to be discriminatory in terms of competition, and you've given public assurances that the design of the bill was certain to not do that. That was one of its key considerations. Can I ask if you've seen BSP's submission and the lateral economics element of that? Which is underpinned by a number of assumptions that they made because literally they are flying blind without information that we are yet to hear from you in camera. Can you make a comment about the modelling assumptions and the scenario definitions in the latitude economics submission attached to the BSP submission to this committee?
It's difficult for us to answer that without then talking about what the liabilities are and the nature of the arrangements, Senator.
So I know that you're going to go to some detail with us. Can I ask, are their assumptions accurate?
Not in our view, no.
Thank you. That might help them.
Senator, could I just add for the record on the Commonwealth Bank that the Commonwealth Bank entered into Nauru for the benefit of Australia's national interests and for the people of Nauru. Thank you.
Thank you.
Thank you. So the committee will now adjourn today's public hearing and proceed to an in-camera session. So I will ask